Hello, chat. Happy Friday. Hope everybody's doing well. I've missed you guys over the last 2 days. I've been busy, but looking forward to doing these rewinds again, these replays. We last left off with our YSL Reunion Part 9. We went back to pre-trial days, December 15th, 2022, and watched my favorite part of like the whole case is Brian Steele's successful fruit of the poisonous tree argument and Love losing her mind over it and trying to fight with the court. Before that, we went through the testimony of Trontavious Stephen, aka YSL Tick, aka YSL Slug, and that was Love's witness, and he was on the stand for like a million days. We've skipped a few days now. We're jumping from, I think it was day 21 to day 32. There were a lot of witnesses that Atkins, I think ADA Stevens, and Hilton questioned. Business records, chain of custody, detectives, and really Love wasn't doing any of the arguing. We're finally getting back to Love in court, and we're going to get a drawn out argument about the admissibility of a 911 call. Even better, we've got 2 DA dispatches. So Fulton County does a newsletter, and in every issue or most of the issues, there's a segment called the Law Corner, usually with Gautam Rao, who I think is currently prosecuting a case in front of Judge McBurney, if you want to go watch him in action. Adam Abate is also prosecuting that case. It's a state v. Dennis. I don't know the specifics of the case, but he is currently prosecuting a case if you want to go watch that on YouTube. We have 2 matters that Steele is going to argue that are in law corners. And these law corners seem to be, in my view, sometimes a bit of advice on how to color in between the lines without going over them, but pushing your bounds and maybe finding a way to find a loophole to do the things you want to do, even if you don't really have the explicit right to do that type of investigative work. And then we're going to get into the argument, argued by Steele on behalf of Jeffrey Williams, and then responded to by Adriane Love on behalf of the state. So, to Mystery, good to see you. Hey, Amanda. Hey, Trakeisha. She says, happy Friday. Friday. Miss Ann, happy Friday right to you. Tracy Talks, happy Friday. And let's see. Did I do the reconsideration video already with the summarily deny comment? I don't think so. There were a few reconsiderations. Do you mean Detective Dennis's reconsideration? Let me know which one. But if it's a love moment, we will get to it. Hey, Factual Lie, good to see you. Hey, Nem. So we're gonna get this first. Let's do residual hearsay first. It's gonna be Steele's gonna say, look, the state can't even raise this argument. They want to, but they didn't raise it, so they can't raise it now. So from Mr. Rao, from the DA Dispatch newsletter from Fulton County, residual hearsay. If there's an out-of-court statement beneficial to you, but the declarant is unavailable, and the statement does not fall under a hearsay exception, you may have that statement admitted under OCGA 24-8-807, which says, quote, a statement not specifically covered by any law, but having equivalent circumstantial guarantees of trustworthiness shall not be excluded by the hearsay rule. So that's the quote from the statute. However, to allow and admit the statement as permissible testimony, the trial court must determine the following 3 things per the statute. So this is what's required. The judge needs to have this to be able to say, yep, I'll admit that. 1, the statement is offered as evidence of material fact at issue. 2, the statement is more probative on the point for which it is offered than any other evidence which the proponent can procure through reasonable efforts. And 3, the general purposes of the rules of evidence and the interests of justice will best be served by admission of the statement into evidence. Once the court has found that the above-mentioned factors have been satisfied, it is within the court's discretion to allow. So they have the discretion to allow the hearsay statement in the trial. Because the court is required to make these determinations, this is what prosecutors need to do. Prosecutors need to know in advance about the statement because the court and the defendant need to be notified about the statement, its declarant, and the person who heard the statement. So you need to essentially give notice to the court and the defense so they can prepare their arguments. It's part of discovery, first of all. And this is the issue that Love didn't accomplish here. She did not give notice of relying on a residual hearsay type of way to get this 911 call admitted. The Georgia Supreme Court has said that Rule 807 applies only when there are certain guarantees of trustworthiness because such statement is considered sufficiently trustworthy due to the circumstances in which the statement was made. That's coming from Tanner v. State. Statements are considered, quote, sufficiently trustworthy, not because of the credibility of the witness, but because of the circumstances the statement was made. Smart v. State. That means we also need to know the nature of the relationship between the declarant and the hearsay witness. Miller v. State. So here's an anecdote here from Mr. Rao. I once had a witness who was the last person to see a victim alive and riding in the defendant's car before the victim went missing for a month prior to police finding his body decomposing in a ditch. The witness told the victim's best friend 2 days after the victim's disappearance about the victim riding away with the defendant. The witness unfortunately passed away, and his potential testimony became hearsay. However, because the witness and the friend had a close relationship, she took care of him when he was sick, cooked for him, brought him home for dinner, in addition to the fact that the statement was made under circumstances where the friends were worried about the victim and looking for him. It had certain guarantees of trustworthiness, and as such, it would be admissible. So there's this thing that could be argued if necessary, and we're going to see that Love doesn't argue it. And we've got one other lesson that I think we can apply from a different issue about 911 calls as business records and the Sixth Amendment. So this is very applicable to what Steele's going to argue. Let me move myself because I'm in a bad spot. Well, it's not quite better. We'll go up here. There we go. In many cases, I'll do it one column at a time so it's big. In many cases that we have to prosecute, and again, this is written for prosecutor education, how you can sharpen your skills as a prosecutor and prosecute more effectively. In many cases that we have to prosecute, many of them contain one or more 911 recordings. So we know that Latner's, how many times did we see Miss Latner's during this trial here?
Oh, help me. All right, let's not comment on the various attorneys.
Hello.
So our primary 911 call record custodian, Miss Latner's, was like a fixture, like a recurring character in this trial. Many of them contain one or more 911 recordings that resulted in police action and investigation of the case. At trial, prosecutors will introduce 911 calls for the purpose of demonstrating the reason behind why police arrived at an incident location, the fear behind the caller's voice, and or one of several other relevant purposes. There are three main ways to introduce a 911 call into evidence. One, you have the caller themselves, the person who actually dialed in the 911 call, come to testify. Two, you have the custodian of records, usually in this case, Miss Latner's, testify to the recording's authenticity as a business record, which is a hearsay exception under OCGA 24-8-803B6. Or three, you can file a notice to introduce business records under 24-8-803B6, accompanied with a certificate of business records signed by the custodian of records indicating that call. There's three subsections here: that the call was made at or near the time of the occurrence of the matter set forth by or from the information transmitted by a person with knowledge of such matters. B, kept in the course of regularly conducted activity. And C, made by the regularly conducted activity as regular practice. Options 2 and 3 come in handy when the 911 caller is unknown or unavailable, because then, so we don't need the original person. We can have Ms. Latner's come in. We can have a custodian come in or unavailable. Then your option to authenticate them as business records is available, even though the caller isn't. However, authentication of the call is all that the business records exception to hearsay provides. Whether the call becomes admissible at trial requires a different analysis. So we've got to do a little more if we have to rely on option 2 and 3. So as a prosecutor, if we want to get this stuff in, and we want this 911 call to go for more than just it's authenticated and a 911 call was made at this point in time, what else can we do to get the jury to hear what's going on in this 911 call? The riddled with bullets. Even though 24-8-803B6 governs regardless of whether the witness is available or not, the Sixth Amendment right to confrontation still applies and may preclude the admissibility of part of the 911 recording or all of it. The United States Supreme Court has indicated that, quote, the admission of out-of-court statements that are testimonial in nature violates the Confrontation Clause unless the declarant is unavailable and the defendant had a prior opportunity for cross-examination. So this is really, we're going to hear Steele argue this part. And what we're going to read is Mr. Rao's coaching, his strategy, options available to prosecutors to counter a Sixth Amendment argument. So what this means is that your 911 call, if your 911 call is testimonial in nature, either in whole or in part, the testimonial portion of the statement in the call will not be admissible at trial unless the defendant had a prior opportunity to cross-examine the caller at a prior hearing. So what statements are considered testimonial? A statement is testimonial if the primary purpose of the statement is to establish or prove past events potentially relevant to the later criminal prosecution. Generally, a statement given to law enforcement during an investigation would be considered testimonial, since the purpose of giving/taking the statement is for the police to investigate and assist in advancing criminal prosecution at a later time. A statement provided to a third party, such as family, friend, acquaintance, will generally be considered non-testimonial, since we typically don't make statements to them thinking they'll later be used in a criminal prosecution. So how does this relate to 911 calls? When providing a statement to law enforcement, and specifically within the context of a 911 call, the Supreme Court in Crawford clearly drew a distinction between what can be considered non-testimonial. The court indicated that statements made by witnesses in response to, quote, questions of investigating officers are non-testimonial when they are made primarily to enable police assistance to meet an ongoing emergency. So this is Rao saying this is the gray area you've got to look for. Basically, if the primary reason behind the statement is to assist law enforcement in the midst of an ongoing investigation, and you might remember Atkins made a lot of these arguments later in trial, this was to help them in the midst of an ongoing emergency, an ongoing investigation, emergency, not investigation. I can picture his arm moving. Then the statement is not considered testimonial, because you're just trying to help with the situation that's happening here and now. There's a bigger issue at hand, this emergency, than a potential pathway to a prosecution later down the line. So that's the key distinction. Then the statement is not considered testimonial. It's a case-by-case analysis that courts have to make, as what is considered an ongoing emergency is a context-dependent inquiry, as well as the intent behind the questions that elicit statements in determining the nature of those statements. Thus, when introducing your 911 calls, specifically when you do not have the caller as a witness, this is what prosecutors should do. Listen to the entirety of the call. Typically, the beginning of the call will be non-testimonial, since the caller is going to be providing the reason for the call and why the police need to come to a particular location immediately. For example, quote, this is my favorite. You guys have heard me read this before. I need police to come to ABC Street because Adam Abate was punched in the face by Gautam Rao, and now his face is all broken. Gautam is wearing I'm saying his name wrong, a blue t-shirt with brown pants and running in the direction of XYZ Boulevard. Please get the ambulance and police. That's his example. Listen carefully to the questions being asked by the dispatcher, as the statements in response can shift from non-testimonial statements to testimonial statements to the dispatcher that would not assist police in the moment. Consider the following example. Quote, okay, so the fight where Gautam completely destroyed Adam stems from an incident that occurred a few hours when Adam went into Gautam's office and started taking things off his desk and throwing them on the floor. Gautam was understandably infuriated, and he called Adam and demanded an apology from him. Adam defiantly refused to do so. Gautam was enraged, so he confronted Adam at ABC and they started fighting. I was present for all of this. Now, and I think he actually describes this distinction quite well. But you can see how some of this stuff can be argued a little bit subjectively. Like, while this statement is helpful and the caller can certainly testify to it in court, if the caller is not available, this portion, all the details about Adam, the stuff being taken off the desk earlier on before the fight actually happened, this portion of the call would likely be considered testimonial, since the purpose behind the statement is more in line with providing narrative than assisting with the apprehension of the suspect or rendering aid to the victim or similar criteria to meet an ongoing emergency. Now, this last line here, and this will happen throughout the rest of the rewinds we're going to be looking through. Anytime they're arguing about these 911 calls, like that riddled with bullets call, watch where the defense argues and where the state argues something to be testimonial and helping to aid in, fixing and dealing with an ongoing emergency versus, no, that was actually something that would aid an investigation after the fact and lead to criminal prosecution. And watch every single time the way the subjective interpretation differs between each side of the aisle. And he finishes by saying, determining whether a 911 call is testimonial in nature is a short but necessary analysis that every prosecutor must make when introducing a 911 call when the caller is unavailable. So I think it's cool to be able to see how these kind of like instructions, this guidance, and these monthly newsletters from Fulton County DA's office to whoever reads them are written, and seeing the difference between the sides arguing in court. So now we're going to get into the actual replay. This is relating to, and I pulled quick context here from Thugger Daily. So this was relating to a 911 call where the woman caller ends up saying somebody named Young Thug shot at somebody. And then the incident in question is regarding Thug being in a car when his friend, DK, Walter Murphy, we're going to get to his testimony later, not today, another day, shot at police. This 911 call is the only evidence that Thugger Daily was aware of that Thug actually shot a gun in that incident, but that may change as witnesses testify. Other witnesses and evidence all points to DK being the only shooter, and Thug ran away from the scene. Steele's going to argue about this confrontation clause, and that this caller didn't actually witness Thug herself shooting, but heard it from her neighbor. So it's residual hearsay within this 911 call confrontation clause issue about the caller themselves. So let's see. And I think this is from Steele's motion. This reads that the unknown female caller explains that she has no idea if anyone was shot or if someone was shot, who was shot, and the only thing that she knows is that her unknown/unnamed neighbor ran to her home and told her that, quote, the guy that shot somebody named Young Thug, or whoever that's supposed to be, shot somebody and the guy is in her house. End quote. The unknown female caller just wants to get her unknown/unnamed neighbor out of the house, but the neighbor will supposedly not answer the phone. All of the above information is testimonial as well as hearsay without any saving exception, as this is background information provided by the non-victim caller who is not in the throes of an emergency situation and ongoing crime. So this is the argument the state has to counter here to show why this 911 call should be admissible. So there's our context, you guys. Yes, Stevie, I didn't know that this was based on a true story of Adam getting punched in the face. Good to see you, Brooklyn, NYC. Hey, delicates of light. Hope you're doing well. Felicia, good to see you. Amy E is in the building. Big thanks to Amy E. Make sure you guys go check out Amy E's channel. She will keep you busy if you're looking for stuff to do. And Taylor, thanks for the context. So Taylor, you were looking for the one where I think Love wanted Whitaker to reconsider her rulings on the Quindarius Zachary video or statements so she could get it played through Gaither. We went through, that might have been like days 1 or 3 of this reunion. We did go through that reconsideration, and that was a good time. And she's insisting, Gaither, it's not that we only want to get it in through Gaither. And she doesn't want to come out and say she really ultimately wants to show all of this stuff through Gaither. Lo and behold. So we did go through that one, days 1 and 3 of this reunion. No, they did not include graphic illustrations to illustrate this story they use as the example, unfortunately. Hey, Bobby, good to see you. So let's get into it, you guys. Let me know. Volume check. We'll get captions up here. And let me go back a few lines. They're already... All right. So here's Steele giving everyone a copy of the brief.
Your Honor, do you need a physical copy of the brief I filed on?
No, I already have one.
Saturday? Maybe Sunday.
It was Sunday. You must think that I don't have anything else to do on Sunday evenings. But yes,
That's actually really funny. So this is back in February. I'm pausing so early into this. But remember, we have the ex parte that we first heard about with Kenneth Copeland, right? You know, they meet in chambers that Monday morning after the weekend that Kenneth Copeland spent in custody. And then we find out down the road that there was actually another ex parte that Friday. And when we got to read the transcript of that Friday ex parte, Love is talking about doing homework, getting homework done. Glanville saying, get that homework done. Send a text to me. I'll have it to you by Saturday. I'll have it to you Sunday. So yeah, actually, I do think you have other things to do on a Sunday, according to this ex parte meeting between you and Love. Funnily enough. But we didn't know that back in February of 2024.
I did get it.
Also, do you have, or do you want a copy, or does anyone want a copy of the 911
I have that
transcript?
too. Come on, let's go. Let's go.
Okay.
Can you provide those
So-
to me? I told you I would look at them so that we could go ahead and you could summarize or kind of be more efficient with your argument.
So I think it would be best with the court's permission, and I'll mark it whatever exhibit number, or if the state wants to mark an exhibit number, that's fine. But if you don't mind listening to about the 3-minute, 30-second 911 call along with the transcript, because I believe that will, then we can get right into the law and use those facts, if that's okay with the court, and you can hear the demeanor.
With Mr. Steele's and the court's permission, stating at this time that that's the case, tender 122C Charlie, which contains all the 911 calls, and specifically it will be the one at 12:30 p.m. on this day that we will be listening to. So I can tender it, and then I can actually play it whenever it is that Mr. Steele wishes to address that portion of it, which is at the court hearing, with the court's permission.
All right, it's the same one. Mr. Steele, do you have any objections to states 122 Charlie?
For purposes of this hearing, no.
Okay, all right. 122 Charlie will be admitted for purposes of this motion. Go ahead and play it, please.
Yes, Your Honor. Do we have, are we up on Zoom?
Let's see.
Okay.
I think we are. Ms. Umana's on a link. I have.
Your Honor, while the state is doing that, may I approach with the cases?
I have them, remember? You sent them to me in your Dropbox.
Would you like a copy of the case?
Sure. But Ms. Weaver says she'd like a copy, so go ahead. Okay. I'll give it back to you. All right, thanks. Thanks for seeing. All right.
Wait, are they both wearing yellow? I think Love's, like, part of her plaid had some yellow in it. Chloe Albert's revenge is gonna find her way now that there's matching outfits.
Atlanta 911 operating 6197. What's the address of the emergency?
It's not an emergency. The guy that shot the guy over here off Cleveland Avenue, he's in my friend's apartment, and she's panicking. She don't know what to do.
Okay, what's going on?
It's a guy, I guess somebody must have shot somebody over here where I said, over here in Summerdale. But you cannot come to my house
Okay, ma'am. When I come to your location, I just need to know what's going on. Was somebody shot recently?
Yes, about 5 police say where I go.
Okay. What's the location?
It's over here on Cleveland Avenue.
Cleveland Avenue. What else, ma'am? I need numbers or 2 Cross Street?
Old Hateville.
Old Hateville in Cleveland Avenue?
Yes. I don't want to talk loud. I don't want to get myself in no trouble.
That's fine. Okay. You said okay, the mail is inside of what home?
My friend apartment, she panicking. She don't know what to do.
Okay, that's fine. Okay.
But she got her mama, her baby now.
Okay. All right. And what's the What's the
number? We stay in the new townhouses in Somerdale. And she stay in building C, but I'm not for sure what the apartment number is. But she stay in building C. When you come around, you come through the gate.
Okay, so who was shot?
I have no idea, babe. I promise I can't tell y'all that. I don't know. All that I know, she came to my house and told me that the guy that shot somebody named Young Thug, or whatever it's supposed to be, shot somebody and the guy is in her house. So I don't know how y'all can do that. I'm trying to get her out the house, but she wants the phone now.
Okay, all right. Okay, so you saying the female won't answer the phone?
I just tried to call her phone. And she got her baby and her mama now.
Okay, all right. And do you want to leave your name or number?
No.
Okay.
Please don't call me that.
Yes,
because
ma'am.
she know my children. No.
Okay, all right.
I want to come back and retaliate this thing.
Okay, what's the apartments or the duplex name?
They Somerdale townhouse. Not the old Somerdale, they the new one.
Okay, is there a gate code to get in?
Never call it now. You got to have a gate code get in, but the back gate is open.
Okay.
Everybody standing out here.
Okay, we'll get somebody out.
Yeah, I'm trying to get her out the house on the mama, but they want the phone now.
Okay.
She don't know what to do. She panicking.
Okay, but she's in the building C, correct?
Building C. When you come around when you come through the gate, come around. But I'm not for sure what the number is on her apartment number.
All right, we'll get somebody out. Okay.
All right, please don't tell us how to make the call.
Yes, ma'am. They won't call you back, and I don't have your name.
All right, thanks.
All right.
And Your Honor, just for the
Now, notice that the first line of that 911 call recording was the caller saying this is not an emergency.
record, I will move for purpose of this motion, the transcript that everybody has, I assume is used, unless you already did that.
Your Honor, I prefer that the call speak for itself, and the transcript is not pertinent to and not evidence of what's on the call. So
What's the purpose of the transcript, Mr. Steele?
For the record, Your Honor, and it assists us in talking about it, and I served it on the state Friday, didn't hear back any issues, so like any other transcript, I understand the recording is the evidence for purpose of motion, but it would assist me in the argument.
I'll admit for a 104 determination at this point.
And I'll mark it, Mr. Williams, number A, if that's okay, since it's a motion, Your Honor, dated today. And I'm going to give it to the court.
Yes, you may.
Okay, so, Your Honor, where we start is there's two issues as the court I would like the court to address. The first one is the confrontation clause, and in a confrontation clause situation, and we're dealing with a 911 recording. There is nothing special about a 911 recording. I saw that the state's reply this morning said that 911 recordings are generally admissible. That's not accurate. That comes right out of Pitts versus State, which I've given the court. The court has.
Yes, sir.
You have to go and look at it. In fact, it's the opposite. Some courts say, the New York courts, which is mentioned in Pitts, say that 911 recordings are always confrontational because it's a citizen or a caller talking with the authorities. But Georgia said, what we're going to do is, yes, it could be confrontational, but it may not be confrontation clause implication. We have to look at each case on a case-by-case basis. Pitts, of course, Your Honor, just for the record, is 280 Georgia 288. It's 627 Southeast 2D 17, 2006. And that came out right after Crawford versus Washington was pronounced in the United States Supreme Court in March of 2000, or in 2004. So this is the first pronouncement on a 911 recording by Georgia, and that's why I used it. And Your Honor, in footnote 11, just because it's old and our evidence code changed, in footnote 11 of Spratlin, SPRATLIN versus State, that's 366 Georgia Appeal, 607-883 Southeast 2D 847 2023 case, they cite to Pitts versus State. And they talk about the confrontation clause implications. So we first have to talk, if you don't mind, and you have to wrestle with and make a decision on confrontation clause implication. Then, and only then, if you do say that I've failed in my effort to say that this is testimonial, then you have to look at the statutory hearsay evidence and whether there is an exception to the general rule that hearsay is not admissible. The state this morning filed a brief that I read right before your honorable court began the proceedings, or a response, I guess. And they said that if the court does not find a confrontation clause violation, and the court does not find excited utterance or present sense impression under the hearsay statute to be met by the state, they then ask for the court to wrestle with 24-8-807, which is the residual clause to hearsay exception, but that cannot be used because the state never gave pre-hearing notice that they were going to use that exception, and that exception is rarely used, and I'll give you those cases. Going back to where we start, though, Your Honor, going to Pitts versus State, and I cited this in the brief that Mr. Williams filed, as you said, on Sunday evening, which would have been, I think, the 18th of February, 2024. And the issue is this, that Your Honorable Court has to do, is Mr. Williams and everyone, God forbid, charged with a crime, have the right to confront the witness. That's how we start. That's how the Constitution put it out. That's generally, in every case, what needs to be done in a criminal setting for the accused. The state has no confrontation clause rights because it's the rights given to the people by the Constitution. So these witnesses or witness, either one of them, the supposed caller or the supposed unknown neighbor, they are not being called as witnesses at our trial. So therefore, it starts out with, this is inadmissible. It's just inadmissible on confrontation clause, unless the court finds that this call is not testimonial. If it's not testimonial, then under Crawford versus Washington, the highest court in our country said, well, then that doesn't implicate the confrontation clause, because the confrontation clause is some utterance being made for the purpose of an arrest, a prosecution, a possible evidence in a trial. So if it's used for that purpose, so that's a primary purpose, doesn't have to be the sole purpose, but the primary purpose, then the evidence cannot come in because these witnesses are not here. If the primary purpose, however, is to stop an ongoing situation, so the victim in the Pitts case, she is married to Mr. Pitts. She is being beaten. She is calling 911. The 911 call is being hung up. She is getting back with 911. Eventually, it doesn't go through the call. The police come out because they have the address. The police find her in a shambles. The place is a mess. They arrest Mr. Pitts. Comes time to trial, Ms. Pitts says, which is valid, under the marital privilege, I'm not testifying against my husband. So she's unavailable. She's not there. So what the trial court did is say, I'm letting in the 911 call because I find that the victim, Ms. Pitts, was observing, seeing, because you have to do both confrontation clause and hearsay, this situation, and she was not calling to have Mr. Pitts arrested for something. She was calling to save her life. It was what they call an ongoing emergency situation. And because of that, the primary purpose, according to the trial court, and then of course, it's affirmed by the Honorable Supreme Court of Georgia, they said this is close. They said we're going to affirm the trial court. They said that because the victim made the call, because the victim was in the throes of an ongoing emergency situation, she needed help. It was not something to just make an arrest. Our case, I think, stops right away with the first words uttered by the caller, because it's the caller now. It's the caller calling for an emergency situation. And the caller's first words when the 911 operator said, what's your emergency? The caller immediately said, and then there's 3 dots. It's not an emergency on Mr. Williams' motion. Mr. Williams' Exhibit A as an Alpha Elisa. Then the next information gets all involved, and it's a short call, but there's a lot of information. The caller does not really know what's going on. The caller says immediately after that, this is not emergency. She states, the guy that shot the guy over here off Cleveland Avenue, he's in my friend's apartment, and she's panicking. She don't know what to do. 911 operator says, what's going on? The unknown caller says, the guy, I guess, she's speculating. Somebody must have shot somebody over here where I stay at over in Summerdale, but you cannot come to my house or through my house. So what she is saying is, she is repeating information that she doesn't know if anyone got shot, but she guesses that, assuming that, and we really don't know the basis. Maybe she knows it because she was told it by the neighbor. Maybe she knows it because she heard it on the news. Maybe she really never knew it at all, but saw police officers in her apartment complex. So this is something where we ask this honorable court to analyze, is this really an emergency? And the reason I say that is because the caller is also not panicked by saying, you got to get here now, you got to get here now. The caller is constantly saying, I don't want my name to be used. I don't want my children's name to be used. You don't have my address, don't have my telephone number. You can't have my name because I don't want retribution. That is the key to this is going to be an arrest. Person is going to find out who's arrested that I made the call and I don't want to be involved. That is totally for purposes of arrest and prosecution, which does trigger testimonial evidence. And if it's testimonial evidence, Mr. Williams gets to confront the person. The unknown caller says that, Your Honor, 1, 2, 3, 4, 6 lines up from the bottom of Mr. Williams A. The caller says, yes, I don't want to talk loud because I don't want to get myself in no trouble. So she's not saying you got to get here, you got to get here, you got to get here now. She has the wherewithal to say, I don't want to be involved. After that, on page 2 of Mr. Williams A for today, the operator asked at the very top where the operator speaking for the first time, okay, so who was shot? And the unknown caller says, I have no idea, baby. I promise you, I can't tell you all that I don't know. And then she goes through, the only thing I know is that my neighbor, she, but I'm assuming the neighbor, came running. She came to my house, told me the guy that shot somebody named Young Thug or whoever that's supposed to be, shot somebody and the guy is in her house. So I don't know, y'all can do that. I'm trying to get her out of the house, but she won't answer the phone. So I asked the court to understand and consider this. When I went through this, I realized that the neighbor then was in the house, according to the caller, but then left the house. So somehow the neighbor's not trapped in the house. The neighbor then returns to her own house. That's what's going on here in this 911 call. So clearly, this is not an emergency where the neighbor comes over to the caller's house and says, call the police. My child and my mother are there, and there's a person in there that's threatening us. I need to run. I need to go back in and help my mother and my daughter because there's an ongoing emergency situation. That didn't happen because we know that the neighbor, according to this caller, if any of it's true, the neighbor comes over, somehow freely leaves her apartment. She doesn't say she escaped from the apartment. She doesn't say that she was being beaten in the apartment. She doesn't say anything. And she uses this term to then say she went back. In addition to that, Your Honor, after the neighbor leaves the apartment of the caller does not call 911 immediately. Because the caller is telling the 911 operator later on, it says, my neighbor will not answer the phone. But then on page 2 of Mr. Williams A, five callers up from the bottom, it says unknown female. That's them calling now. Meaning that the neighbor went back to her home or went wherever she went, and she made a phone call to the caller, unknown caller calling 911. That means that all of this is a mishmash. In addition to that, the only place in here that names what I'm going to say, I'm going to adopt Jeffrey Williams, Young Thug. Where did that information come from? It can be presumed that it came from the unknown neighbor, but did it come from someone else? Because it says that shot somebody named Young Thug or whoever that's supposed to be. So was Young Thug shot? Did Young Thug do a shooting? I don't know. But when it says somebody named Young Thug or whoever that's supposed to be, without this caller here asking her questions, pointed questions, saying, where did you get that information from? It is a violation of Constitution Clause rights. And Pitt says that if you find some statements testimonial, some statements non-testimonial, you redact the statements that are testimonial. Where Young Thug, whether he was shot, it says that shot somebody named Young Thug, whether Mr. Young Thug, Jeffrey Williams, was shot or not, or did the shooting. The bottom line is that doesn't go to the emergency. That information comes from somewhere that we have the right to cross-examine. So that would have to be at the minimum redacted, respectfully. I think the whole thing is testimonial, though. At the end of it, Your Honor, the 2 line in page 3 of Mr. Williams' Exhibit A, as in Elisa Alpha, if you go up to the first time that the caller is speaking on that page, it says unknown female. All right, please don't tell anyone I made this call. That does away with all of the belief that when you're in a panic and you're calling for help, you don't think about things like, don't tell them I called, because it's supposed to be so fresh that the only issue is, I need help, my building is on fire. I need help, the glass just broke and I'm covered in bleeding. I need help, I just had a heart attack and I'm laying on the ground, I'm losing consciousness. I'm not worried about, by the way, retaliation or don't use my name. So, Your Honor, for all of those reasons, or any one of those reasons, I respectfully ask this honorable court under Pitts versus State that this 911 call, and the words that they use is bears, which is B-E-A-R-S, testimony, quote unquote, against Mr. Williams and implicates the concerns of the confrontation clause. That is an objective standard. That is an objective standard. That is a reasonable person. It's not the caller's standard. In addition, Your Honor, under Pitts goes through the long process, and all these cases go through a long process, that the caller was or was not in immediate peril. Here, the caller is in no peril. She is reporting something of somebody else. She didn't see anything. And that's in Pitts versus State. And they specifically wrote, our highest court wrote, the caller was not in immediate peril, but was calling to report the defendant's whereabouts description and the fact he had violated a court order. And they're citing to a New York case. It's State versus Powers, P-O-W-E-R-S. So, Your Honor, here the caller was not panicked. She said it's not an emergency. I'm not going to repeat, but it's all of the issues that I am raising. If your honorable court finds that this was testimonial in part, and you redact some, but you don't redact some of the call because you find that some of it's non-testimonial, that is what you're supposed to do, and that again is under Pitts.
What about if this phone call were made to thwart an ongoing crime, which arguably might be occurring? How would you respond to that?
It depends on the circumstances. So
I will get this circumstance.
this circumstance is, we really don't know if there's an ongoing crime. She doesn't know.
So, am I crazy, or did Steele not go through? And I think the 911 call, it's not like there's many interpretations about that call. That woman, whether she's genuinely being truthful about being afraid to say her name or whatever, if she's actually making truthful statements that this person did tell me this, right? Put that aside. It's not really that ambiguous about whether or not there's an emergency presently ongoing. And Steele goes line by line describing that. And then Glanville comes in like, well, would the circumstance be different if there was an ongoing emergency? And Steele's like, well, it would depend. And that's what the case law says. It depends on the circumstances. And then Glanville goes, well, what about this circumstance? Why are we circling back to the thing we already covered? We went through the details of this specific 911 call already. And then we went through the case law to support, the analysis from Steele on why the majority of this 911 call is testimonial.
Oh, she says somebody's in there that was shot or shot.
She's relaying third party information.
Yes, and you can't assume, at first, when I first listened to this, Your Honor, I thought, oh, okay, this is coming directly, from a listener, from the neighbor. Then I realized I have no idea who this is coming from. She never says, meaning the caller, I got this from my neighbor. It says my neighbor.
Referencing some other person.
Exactly. I don't know if she got it from a third neighbor or someone else called her, et cetera. So I really don't know where this information is coming from. So I hope I've answered your question, but in this particular circumstance, I'm not even so sure there's an ongoing emergency. And I say that because objectively, the neighbor goes back to the home. Let me start here. The neighbor left the home in a panic, says this person's in my house, whatever happened, goes back to the home, and then is calling the unknown 911 caller. So clearly the neighbor is free to use a cell phone, free to enter her home, and free to exit her home. That doesn't sound like anyone is saying, I am being held against my will. I am being accosted. I am being the victim of something. It sounds more like they are reporting that a shooting happened and either the person was shot or the person shot someone, and that is not the ongoing emergency that we are talking about. Through this caller, it would be different if it was the neighbors supposedly calling and saying, this is what's going on. I got to keep my voice low. I don't want to speak loud. All the things that are adopted here by the unknown female. Then I believe that it's a harder case, but we'd have to analyze it if those were the facts, so I've changed the facts. But that is not what we have here. And I just can't get over that this is not an emergency. And that's just, we have to ignore that statement. We would have to ignore that statement to answer your honorable court's question. We have an ongoing emergency. What do we do? And the first lines were what I said, this is not an emergency. And we don't know how much time passed. There's a lot of assumptions. Did the neighbor come and leave and call, and when not answering the phone, was that in 5-minute time span? Was that in an hour time span? Was that in a 30-minute time span? Was that in a 2-hour time span? We don't know.
That's really important because there is case law that the time frame between when something actually happens versus when it's being said, when it's being talked about later, can make the difference between an excited utterance exception to hearsay. And we just don't even have that context here. And we can't get from the demeanor, oh my God, I'm so scared right now. I have an elevated voice and I'm telling you right now that those are things that indicate an ongoing emergency. We don't have that here either. So is there an excited utterance? Is there an emergency? It's like all of these tick boxes that favor the defense's argument here are being ticked.
So I asked the Honorable Court to find its testimony because the primary purpose was not the emergency, as she said.
All right.
If you jump to the, you know, I mean, if you say, no, I disagree with you, Brian, that's wrong, or I disagree with you in part, whatever, I'm going to redact parts of it, then your Honorable Court is bound to go through the hearsay analysis because it's still hearsay. Because it's clear that this caller did not see anything. She got information from third parties, neighbor, and maybe others, and we don't know. And because we don't know who else, that is clearly a confrontation clause as well as a hearsay problem for Mr. Williams if you let it in. So what we have here, and that's in, by the way, Spratlin, SPRATLIN versus State, which I cited before, Your Honorable Court. I said earlier today, and I'm just quoting from the court's opinion. Importantly, only after, and it's like bolded in the Court of Appeals opinion, only after a court determines that a statement is non-testimonial in nature do the normal rules regarding the admission of hearsay apply. So what I would like to do then is go through, possible exceptions. And the only two I know of, because this is clearly hearsay. It's an out-of-court statement offered into evidence for the truth of the matter asserted. If it's not being offered for the truth of the matter asserted, then it has no probative value under 401.
Yeah, so the issue, it's to prove that Young Thug was somehow involved in this overt act that's being named in the indictment, because he wasn't charged. He doesn't have a charge for this incident. It's overt act. And the purpose that the state has is somebody said Young Thug.
402. And the prejudice would substantially outweigh any probative value. So going under hearsay then, and I looked at all of the exceptions because the general rule, of course, is that hearsay is inadmissible in a court when used to prove the truth of the matter. And that is 24-8-801C as in Collette. So what happens after that is the only two I found that may be appropriate, and I'm not conceding but when I say that, but maybe, even in play are two of them. And the first one I have is the present sense impression. Present sense impression, that person has to witness it. What they're talking about, they have to observe it. So I saw a person jump out of the building that I was in, and I saw the body come through my window. I saw that and I related. I saw the smoke come out of the car, and then it went boom. I heard the shots, the gunfire. Those are all issues that I can relate because I observed it. This person, all she observed is my neighbor came in a panic. Came into my home, went back to her home. I called her, she wouldn't answer the phone. She called me while I'm on the phone with 911, and it's not an emergency. That is it. And if the state stresses, hey, this neighbor came in with a panic, you can't just look at the panic. You have to look at the caller said, this is not an emergency. Those two collide together. Like you always say, it's a battle of the titans, it's a collision. These two statements collide together. You'd have to ignore this is not an emergency to then say, oh yeah, this is an emergency because she's panicked. So present sense impression cannot apply by definition because the caller, excuse me, Your Honor, did not personally witness any startling event except that her neighbor came in for a panic and she said this is not an emergency. Everything else related is total hearsay without exception for present sense impression. Then, the panic, but yet the neighbor's able to come in and out of her home and call the caller of 911 again while the caller's on 911. Finally, Your Honor, present sense impression it happened so fast, I observed it, and I'm relating it. There's no time to think about repercussions of what you're saying. It is the instant. Cases say it, and it's in the Grimes, Grimes versus State, 346 Georgia Appeal 518, 875 Southeast 2D 500, 2002. And there the second highest court in Georgia wrote that the statement was not a present sense impression when, at the very least, there was an intervening walk or drive between the event and the time of the statement. So here, Your Honor, it can't be a present sense impression for the caller because we know already that the statement allegedly happens through the neighbor. The neighbor leaves. The caller then, unidentified caller to 911, is calling the neighbor and saying she won't answer. So there's the walk or the drive. It's not present sense impression and it's hearsay. Those are the two layers of hearsay, double hearsay, that the state has to meet both exceptions because you have the statement being made by the caller, you have the statement being made by the supposed neighbor or third parties. So, Your Honor, we don't have a designated time for which this statement was made, and therefore this is not contemporaneous, and present sense impression does not apply. The excited utterance exception, present sense impression, by the way, is 24-8-8031. The excited utterance exception, Your Honor, is 24-8-8032. CAD reports, 911 calls contain inadmissible hearsay. That's in Kamusko, K-A-M-U-S-O-K-O versus State. That's at 362 Georgia Appeal 2768, 68 Southeast 2D 253 is 2002 case. And Your Honor, specifically the Court of Appeals discusses that in the very top, it's under Division 2A as in Alpha Lisa. We turn first to Kamusoko's argument that the CAD reports were inadmissible because they contain hearsay. It is undisputed that CAD reports in this case included statements made by victims, witnesses, and officers to the 911 dispatchers. So what we have to do under excited utterance is figure out whether the statement related to a startling event or condition while the declarant was under the stress of the excitement caused by the event or condition, and they shall not be excluded by the hearsay rule. Here, there was no stress seen by the caller. The caller's stress, quote unquote, is the neighbor comes to see her. But the caller says again, and I feel like I'm repeating, this is not an emergency. There's no stress. The caller is saying, I don't want to be involved. I'm not giving over my name, my telephone number, or my address. The caller is saying, hey, I'm thinking about it. I'm going to talk low so nobody can hear me because I don't want retribution. All of that goes to, this is not an excited utterance because there is time to think about fabrication, coaching, or confabulation. And that is the foundation of the excited utterance exception to the hearsay rule, is that such a statement is made under circumstances that completely is the word used by the courts, eliminate the possibility, even the possibility of fabrication, coaching, or confabulation, and therefore the circumstances surrounding the making of the statement provide sufficient assurances that the statement is trustworthy and that cross-examination is of, and this is what I'm stressing also, absolutely no benefit. Absolutely no benefit. The critical inquiry on whether the excited utterance exception to the hearsay rule applies is whether the declarant, that is the speaker, is still in the state of excitement resulting from that event when the declaration is made. Well, this caller can't be in that excited state because she is claiming this is not an emergency and she has the wherewithal to say, I don't want to be involved. She says that at the beginning, it's not an emergency. At the end, her last words are, her second last words are, don't tell anyone I made this call. So, Your Honor, in this case, I respectfully request that the excited utterance as does not apply either the hearsay. So I believe it's barred by confrontation clause. I believe it's barred by the hearsay rule. If Your Honorable Court goes further, though, there are two layers of hearsay. How did the neighbor get this information? How did the neighbor know that, and I'm adopting it in the most light, unfavorable to Mr. Williams. I'm not saying I agree with this, but Mr. Williams shot someone. She never said, I saw it happen. No one's saying that it shot someone in her apartment. So she was told that. Was she told that by Mr. Williams? I don't know. Was she told that by a neighbor? I don't know. The caller also says Mr. Williams was shot or Young Thug was shot. So you're getting conflicting information, how you want to listen to it. It doesn't matter. But that caller is relying on the supposed neighbor. And we don't know how the neighbor got that information. So without that information, there are two levels of hearsay that have to be cleared by the prosecution. They have to run through both of those walls after they run through the stronger wall of a confrontation clause issue. So I ask your court not to deny this motion and to grant the motion in whole. If you grant it in part, I would like the Honorable Court to focus on the young thug comment, because nobody knows young thug is in the apartment, young thug got shot, or young thug shot someone. And without that information coming in through a proper means, Your Honor, we are totally hamstrung. As the court knows from being a litigant, as well as I'm sure I've never had the honor of wearing a robe, but from watching people get cross-examined, that is I think it's called the crucible that separates American jurisprudence from every other trial in the world, because I think the U.S. Supreme Court and Georgia Supreme Court have said that is the ultimate truth-telling event. And Mr. Adams and I cannot confront any of these people in this case. And just playing a 911 recording, it is impossible to get information from that recording. Your Honor, I'll answer any questions. I hope I was beneficial to the court, and I want to thank you.
Okay. All right, thank you, sir. All right. Yes, Ms. Love, go right ahead.
He laughs. And for context, I put the date in the banner on this call because we're going to, I believe with the evidentiary arguments we're going to get through today, we're also going to hear about something else that happened in May of 2013 that's supposed to be another alleged robbery and possible shooting, supposedly involving both DK and Jeffrey Williams. And we don't exactly know this 911 caller. It seems like she was never identified. It happened 10 years ago. She didn't state her name. She didn't give the dispatcher her information. But what's going on in my mind is, what's a vehicle that people use and abuse when they want to get somebody in trouble? They could call 911 and they can make a false report. What's a reason someone might not want to give their name when they're making a 911 call? They don't like the police is one. They don't want to be in trouble for filing a police report might be another. Maybe a little bit of both. Maybe they had something to do with it. There's plenty of reasons why somebody might not want to give their name. And some of those reasons would go to supporting, they could be saying something truthful but don't want to give their identity. But some of those other reasons would support, they don't want to give their name because what they're reporting isn't truthful. Right? So there's a lot of issues here, and it can be extremely prejudicial to have something introduced to a jury that's not only introducing testimonial statements without the defendant having a right to confront the person who's making those statements, but also the issue of, just hearing someone made a 911 call about somebody and not also hearing that, hey, that could have been a false report. That's extremely prejudicial. But we're going to have another thing come into play in May 2013. They're going to go a little bit out of order. This is in relation to a September 11th, 2013 911 call. And stepping back into the future, I'm also thinking of the young Scooter story that happened recently, and that woman was charged with false reporting or some similar charge. But the storyline seems to be, it's still ongoing. I don't think we've gotten the full case details out. But a woman, while she's in another county, makes a 911 call, and the dispatcher was able to see that she was calling from another location. But she claimed during that 911 call that she was present on the street and seeing somebody was beating a woman that was dragged out of a house that was having a party. Send help immediately. Somebody has a gun. And the cops go and respond. And in the midst of it, they end up shooting young Scooter in the leg, and he ends up dying. Young Scooter dies. Lo and behold, it seems like this woman was just trying to call in a support about a different individual at that residence to get them in trouble, while supposedly keeping her hands clean. That obviously didn't work. So as much as I don't like to think that people do this type of thing. People lie on other people just to get somebody else in trouble. People play and abuse tools like the 911 dispatch system. Just saying, it's a possibility. It's a possibility. And a defense attorney should always, if we don't know exactly what spawned a 911 call, we didn't get to investigate it, this is 10 years later, and you don't even know who the caller was, heck yeah, we're going to fight for the admissibility. So And Sammy with boots on the ground experience says, I work in dispatch. Thank you for doing that job. I always admire dispatch workers that can keep calm and collect the information that they need to get. I would be like, oh my God, are you serious? And says, I don't like the police either. So yeah, it's very, or Glorilla. There was that big story yesterday in Forsyth County. Somebody breaks into Glorilla's residence. She's not even home. But there's a burglary, right? So they find out there's a burglary, so they respond to the burglary. I don't know if it's reported with the home camera system or whatever. But then they find drugs, they find marijuana in the bedroom closet and end up arresting Glorilla. So it's one of those things. Why would there's a risk of making a 911 call where the outcome's not going to be so good for the person calling for help. So, and, just coincidentally, that's not Fulton County, that's Forsyth County, but another Georgia story, just like the young scooter story, also Georgia. And these 911 calls, people play games. The police, when they first respond, they play games. So there we go. Well, that was partly my attempt to give a break before we listen to Love's counter argument here, but let's see.
Thank you, Your Honor. Judge, I'll start with the words panicking, doesn't know what to do. Her mama and her baby are in there. I'm trying to get her out of the house. She won't answer the phone. She doesn't know what to do. Please don't tell anybody that I made this call. I'll refer first to the case that Mr. Williams brought up as being the most illustrative of the point that he seeks to most emphasize to this court, that somehow the 911 call is inadmissible because it violates the confrontation clause, and that's Pitts versus the state. On page 3 of 4 of the copy of Pitts given to the state and to the court, I believe by Mr. Williams, the court does an analysis, and specifically in paragraph, the first paragraph on page 3 of 4, it notes that coming from page 2, that the caller in Powers called to report a defendant for a recent parole violation. And the court noted in Pitts that the caller made the call to report a completed violation of law, and noted that the caller's sole purpose was to make a report of the fact that the caller or that the perpetrator had violated an earlier court order to establish evidence that could be used in a future prosecution. And the court in Pitts noted that for these reasons, the statement was testimonial. It then went on in paragraph 2 to look at the caller in Pitts and to note, importantly, that telephone call was made to avert a crime in progress or to seek assistance in a situation involving immediate danger. The reason that I started out with the caller's words, that my neighbor is in a panic,
Sammy,
is that listening, and the reason that we wanted to play the call for the court is that it is apparent that the sole purpose of the call is to get assistance for what the caller perceived as an immediate danger. She is akin to a person witnessing something violent going on, being afraid of whomever it is that is committing the violence, seeing a policeman pass by, grabbing the officer and saying, hey, go look over there in that alley. So a man is attacking a woman. Don't tell him I said it, but Johnny is over there beating his wife. But
okay, this is a bit of a crazy example because I'm thinking of that young scooter example where that was a fabricated report and it ended up taking the life of somebody that wasn't even named in the 911 call.
You didn't hear it from me, but go help the wife while Johnny is beating the wife. The assertion that because the caller does not want to make her name known to the police or does not want to get herself in trouble flies in the face of the obvious fact that those facts make it apparent that this caller is not calling to establish any evidence for the purpose of a future prosecution. Her sole reason for calling is to get this person out of her neighbor's house. And this is not some secondary, third party kind of situation. The caller herself has experienced her neighbor coming to her in a panic.
You see how she's trying to use hedging language. She's trying to get around the residual hearsay, which she wasn't actually arguing. A viable reason to allow residual hearsay to be admissible in this circumstance. She can't argue that now because you have to argue that in advance. Well, now she's trying to find another way to reword that. Well, this isn't second or third hand, but it is.
So we get past the conference.
She's like, it's firsthand because the caller is the one directly telling us what she indirectly heard. That's not how it works, love.
Confrontation clause quite quickly if we simply listen to the call and listen to the information being shared. A testimonial circumstance is akin to somebody sitting in an interview room giving testimony that they know will be used in a future prosecution. This is a woman who is so frightened herself, she doesn't want to call any attention to herself, let alone have anything she says be used in a future prosecution. As a matter of fact, us using this right now is probably the very opposite of what she ever intended to happen, because her sole purpose was to gain aid and assistance for that baby, that mama, and that neighbor that came to her saying in a panic, "Young Thug's at my house." So
that's not what was said. That's not what we can derive from the transcript.
Our first argument, Your Honor, is that this is not a confrontation clause issue by any means. Just to give the court a little bit of background. On this date, September 11, 2013, officers had gone to this apartment for a reason altogether unrelated to any shooting or anything like that. When they got out there, they heard gunshots and they saw Walter Murphy, who we later learned was Walter Murphy, shooting at a man named Derek Dotson. The officers turned and went to pursue Walter Murphy. And when they did, he jumped into a red Nissan. And they noted that there were 4 individuals in the Nissan. The Nissan comes, speeds off, crashes over a wall and crashes into a brick wall. 4 people get out running. The CAD report relays exactly the sequence of events. We will be entering into evidence 911 calls, the first 911 call that got the officers out there, and then the court will be able to hear the sequence of events. And around the time that this person made this call, just before, the court will hear officers saying, one just went under the car, the other one went a different way, and they're describing the places that each one of them went. So in the midst of all of the commotion that is going on and being relayed over radio traffic, as a matter of fact, we have 2 different numbers, 2 different case numbers that are associated with this particular case. One ends in 1038, one ends in 1308. They get another call that they don't even realize is related to the call involving the shots fired. And that other call is the 911 call that the court heard today. And when they reached out over the radio and said, we got this caller who's calling in about this guy, the shooting at Summerdale, Young Thug, they then learned that it's related to the first series of calls. And that's how they all got put together in the first place. So it doesn't happen in a vacuum. It doesn't happen after any prolonged or any period of time whatsoever. It's actually a series of very fast-paced events that take place. So the car goes over the retaining wall, the 4 occupants get out and run. The police are telling each other over the radio where the occupants are going. And in the midst of all of this, the police get a call from a woman, frantic, not wanting to be identified, describing her neighbor having come to her in a panic just a moment ago, and now she's not answering her call. For all she knows, that neighbor is in there dead. The reason that she is saying what she is saying about the shots and the police, she's not even able to get it out in a very cohesive way. She's saying, I don't know, just come now. Her whole purpose for calling was to get the police to respond to what she perceived as immediate danger. So the idea, though it was kind of glossed over, that this is testimonial, is belied by the contents of the call and the circumstances surrounding the call and the information relayed during the call. So before I leave the fact that it's not testimonial and that it's made solely to get the police there to respond to what this caller perceives as a circumstance involving immediate danger, with the court's permission, I'll pause and ask the court if the court has any questions that I may answer for the court regarding the confrontation clause, because I don't want to conflate the issues.
How can you tell that it's not I mean, that who the unknown female is talking about? I assume that you're not bringing the unknown female or the neighbor in. Is that correct?
So, Your Honor, that is correct. And that would go to the issue of hearsay that I'll address in a moment, apart from the confrontation issue. And I do want to point out, in Michigan versus Bryant, our highest court notes that an assessment of whether an emergency that threatens the police and public is ongoing cannot narrowly focus on whether the threat solely to the first victim has been neutralized, because the threat to the first responder and public may continue. So when the court is asking whether we're going to bring them in or not, I, with the court's permission, will speak to those matters.
Well, I don't get to that until I determine whether or not it's a confrontation.
Yes,
or
Your Honor.
testimonial. But the issue is, she starts up by saying it's not an emergency. And I'm looking at this because I'm being asked to exclude comments that or statements related to this particular 911 call. Ordinarily, 911 calls have to be looked at on a case-by-case basis. And I think that Pitts and Spratlin and Grimes all kind of indicate that. So I got to look at that. But I also am looking at the fact that her statement is, I have no idea, baby. I promise you, I can tell you all. I don't know. The only thing I know is she came running. She came to my house. She told me that the guy that shot someone named Young Thug or whoever that's supposed to be shot someone, and that guy is in her house. So we don't really have, I mean, there's no granularity. I agree with Mr. Steele about what is actually going on. I could parse out several hypotheticals of what she calls or claims may have happened. And it's unlike Pitts and the other cases where you've got somebody who's making that call. You're basically, it's already in a third party situation, because she's relating kind of what she thinks is going on. Now, so that's kind of what I have to kind of decide to begin with. Is the call primary purpose testimonial for the purposes of prosecution or gathering information for later? I can see how it could be either one, but I have to kind of take a look at the facts and circumstances to make a determination as to that. So, but unlike Pitts, the victim is making those calls.
So, Judge.
So in this case, you got a third party who really doesn't we don't have granularity of what she's talking about. I mean, and so I have some problems with that to begin with.
So I would like to separate out and point out that the content of the call, the fact that there is a matter that she is trying to get the police there to address, and the credibility of the content of the call is a matter, again, that I believe belongs within, is it hearsay and is there an exception? Before we get to what she is saying as it relates to whether or not this is trustworthy, and I believe with respect that is what the crux of that particular issue that the court just pointed out, is it trustworthy? This is a third person making a call about something she just experienced. So is what she is saying trustworthy?
I'll give you that much, but.
And so for the purposes of that, Your Honor, I believe that will fall after the court makes that determination as to the confrontation clause. And as in Davis versus Washington, Your Honor, 547 U.S. 813 at 822, the United States Supreme Court distinguished, of course, testimonial and non-testimonial statements, saying that non-testimonial statements, when made during a police interrogation under circumstances that objectively indicate the primary purpose of the interrogation is to enable police assistance to meet an ongoing emergency. And that is exactly what, even if she says it's like, it's not an emergency, don't make a big deal out of this, come get this person out of my neighbor's house. Essentially, that's what she's saying. I don't want to call it, the reason she says, and it is apparent from the call, objectively listening to it, the reason she says it's not an emergency, even though her voice is panicked, is that
I don't think her voice is panicked. She's kind of just talking. I mean, she's talking in low tones. I don't, at least from the court's perspective, I'll disagree with you. I don't think,
yes, Your Honor.
I don't think it's an emergency. I mean, she herself says it's not an emergency. She's like I said, I got to look at the primary purpose for the call. Is the primary purpose for the 911 call to provide information that may be used later, or is it for an emergency or some other reason? Pitts kind of distinguishes that because you got somebody who's getting their, for lack of a better word, their behind torn up, and she's calling, and there's certainly where it could be argued that truly is an emergency. In this particular circumstance, it seems like she's relating information because that's the first thing out of her mouth. I can't discount that. The first thing out of her mouth is not emergency because 911, what's your emergency? And she's not saying, hey, my neighbor is getting blah, 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 or that I heard this and this, and I've seen this, and that's kind of where we are. Where she's relating a third party. I mean, and that's kind of that's the issue of whether or not I got to struggle is whether or not it's testimony or for the purpose of primary purpose. Okay. I could see how I understand the state's argument. I understand the defense argument. That's what I got to kind of wrestle with to begin with. And then I'll decide whether or not it falls under any of the exceptions to the hearsay rule. I agree with Mr. Steele. You didn't give notice under the residual hearsay, so I'm not going to consider it under that.
Your Honor, and Mr. Steele did point out the very last argument that we made and sort of went past the first two. But going back,
you need to focus on whether it's testimonial, because if I don't find it's testimonial, I don't have to go to the other two. The other second prong. First step is if it's testimonial, it ends there. If I find that it's not testimonial, then I'll move to whether or not it falls within a hearsay exception. But I'm not convinced it's not testimonial yet.
Your Honor, I'd ask the court to look at Varner versus the state, 306 Georgia 726. Your Honor, and in Varner, the court states.
What was the citation?
306 Georgia 726, specifically at Penn site 731. Your Honor. And it's on page 6 of 10 of the copy that I believe was provided to the court by Defendant Williams of Varner.
I don't think I have Varner.
Okay.
Oh, wait. Before I start telling you that. No, I don't have Varner.
Okay. It's at Penn site 731. And that was again 306 Georgia 726 at 731, Your Honor.
Peter's like, please shut us down. Please end this.
And in Varner, Your Honor, the court notes that an assessment of whether an emergency that threatens the police and the public is ongoing cannot narrowly focus on whether the threat solely to the first victim has been neutralized, again, because the threat to the first responders and the public may continue. In the case that we have here, Your Honor, if we listen to, and the court has listened to, the 911 call and what the caller is saying to the police, she is simply asking them to come now. And we can, if the court would prefer or like for me to play the call again, just so that I can point out those areas, I would like to, with the court's permission, play that 3-minute call again.
I've listened to the call. I mean,
So when the caller says, just come, she's in there and she's not answering. Just come. You've got to come. She's in apartment C. We're in Somerdale. She is giving instructions to the police, to the 911 operator, how to get to where her friend is. She's saying, only thing I know is she came running to my house, and she's cutting off the 911 operator. So, Your Honor, even if it is not in a tone that the court would say is a panic tone, she is so eager to get the police there that she cuts off the operator on multiple occasions, just trying to tell them to get there. She is describing, as she is talking to them, the 911 operator says, okay. And after she says, if the court is looking at defendant's transcript, just so that we can get past this part in an expeditious manner, the 911 operator, after she says, okay, that's fine, okay. And she's saying, I don't want to talk loud. I don't want to get nobody. I don't want to get myself in any trouble. So she's saying, I don't want to get the person over there in any trouble. I don't want to get myself in any trouble. I don't want anybody in any trouble. I just want my friend safe. She's not saying, I want somebody who said somebody might be in trouble. She's saying, my friend came here to my house panicked, and she doesn't know what to do. And she went back to check on her mama and her child, and she's not answering. And it's all happening in a matter of moments. And that's apparent because of the way that the calls come through and the radio traffic comes through. I tried to reach her. She doesn't say, she just called back and said she's okay. Her primary purpose is to get assistance over there to have someone come and get the person out of her friend's house. I don't want to talk loud because I don't want to get get myself in any trouble. And so she's talking to the operator. The operator is saying, okay, that's fine. Okay. And then the caller is saying, but she's got her mother and her child in there. And as the operator says, okay, all right, and before the operator even gets out all of her words, the caller says, I just tried to call her cell number. I just tried to call her. I just tried to call her and I have no idea. So the operator is trying to get what information one might argue is information that someone could use later for the purposes of a trial. She says, who was shot? She's saying, I don't know. Look, all that I know is my neighbor came running to my house and she told me that the guy that shot somebody named Young Thug or whoever that's supposed to be shot somebody and the guy is in her house. So I don't know how y'all can do that. I'm trying to get her out of the house and she won't answer her phone. I just tried to call her phone and she got her baby and her mama in there. And then they're trying to get information from the caller that could be used later in a future prosecution. Okay, do you want your name or number? She says, no, please do not call me back. He knows my children and no, I don't want him.
Hey, Glanville should have just let her play the call. Because we could have had a 3-minute call being replayed, or now we have this. We have her repeating the whole call with her narrative.
Him to come back and retaliate against me. And then the operator is saying, okay, all right, ma'am, where are you? Do you want to give me at least where she is? She's given the description, the Summerdale townhomes, not the old Summerdale, the new ones. And then she's saying, basically everybody is standing out there. So apparently she's trying not to be loud. She doesn't even want the people outside to hear her. And she says, I'm trying to get her out of the house and her mama, but they won't answer the phone and she don't know what to do. She's panicking. Building C, come around and come through the gate and come around. I'm not sure what the number is on her apartment number. Please don't tell anybody I made this call, but come around. She is imploring them to come. This is the epitome of somebody imploring another person, please come give assistance. I believe that there is an ongoing danger. Without saying my neighbor could be dead, her mama could be hurt. She's saying the words that she believes will get the police to her. She's telling.
Well, I mean, she's not so scared that she didn't say send an ambulance and police, because I'm pretty sure, maybe I'm wrong, maybe I'm piecing together somebody's argument and mixing it with what was in the recording, but I'm pretty sure ambulance was mentioned.
Telling them like there's danger here. This is not just, if she was just calling to say, I want you all to have record. I mean, I've called to report a tree being in the road, and I'll say it's not an emergency, but somebody needs to come and move this tree. It's in the middle of the road and I'm seeing people swerving. Somebody needs to come and remove this tree now. I'm not calling for the purpose of establishing testimony for a future prosecution. I'm calling to have somebody come remove the tree in the road. And in the same way, when she called, she's saying, I'm not calling, to set this up in any future way, but I need you to come get this man out this woman's house.
All right, let's put a pin in that. Move on to the, do you believe if I do find it's not testimonial, how are you going to overcome, or what hearsay exception does it fall under? Because it's clearly hearsay.
Two hearsay exceptions.
What exceptions do you have? And also, how do you deal with the fact that you have no known speakers? You don't have any declarants. And you've got basically you've got double hearsay.
Double hearsay.
Double hearsay. So,
and of course, Your Honor, in 24-805, the new evidence code specifically addresses hearsay within hearsay. So it's not like a taboo subject. Hearsay included within hearsay shall not be excluded under the hearsay rule if each part of the combined statement conforms with an exception to the hearsay rule. So let's start with the internal hearsay, if you will. The person coming to her apartment, because that's the most deeply embedded one. She describes her as coming to the apartment in a panic. Her mother and her child are in the apartment. She needs help and she's scared. And she goes back, she relays to her, he just shot somebody. He's in my apartment. It's apparent that it's well known what's happening because she's describing everybody is out here. She is in the Summerdale, in the community that is the area where the shots took place, where the court will hear evidence of officers and they're responding to this shooting that took place. So everybody can hear it. She's there. She's relaying to her neighbor in a panic. The neighbor is describing the neighbor's present sense impression was she's observing this person in a panic.
this person in a panic is making excited utterances to the neighbor that calls 911. So the excited utterance comes from the person who the neighbor calls 911 to gain assistance for. This panicked friend of this caller comes to her in a panic. She's telling her, my mama and my child are in the house. And this man, young thug, who just shot somebody, or a shooting just occurred involving this person, is in my house. She doesn't even tell her to call 911. She just comes to her for help. She's not trying to establish anything. Of course, the courts put a pin in the confrontation clause issue, but she's not even trying to establish anything for any future prosecution. She's just trying to get help. And the neighbor, being a good neighbor, she's like, I can't help him. You know, I don't have any way to help. I don't want anybody. I got kids. He'll come after my kids. So she calls and then tells the police her present sense impression. She is relaying information that she got, and she herself is still under, the neighbor that calls, she's still under the impression of what just occurred. She's still under the stress of her neighbor having come to her in a panic.
But it's not an emergency. Remember, she started out by saying that.
It's an ongoing danger. Emergency or ongoing danger. The court literally addresses them both and doesn't say, and it says to avert a crime in progress or to seek assistance in a situation involving immediate danger. So where I might not consider a tree across a road where there's heavy traffic coming fast an emergency, the police might, the person that hits the tree and crashes, you know, and ends up paralyzed might have considered it an emergency. The fact that I don't use the word emergency doesn't make it any less of an effort to seek assistance in a situation involving immediate danger. Her words reflect she's panicked, she's not answering her mother and her child. She has said every hot button word that would get assistance quickly to any objectively listening person. If someone called you and said those very same words to you, if a neighbor of yours called you and said, oh my God, Sally across the way just called, she just came over here panicked, and now she's in the house and she's not answering. She just came over here. She said this guy that just shot somebody is in her house. I'd ask Your Honor, what would Your Honor think? And what would Your Honor do? Would Your Honor consider that call from your neighbor one that the neighbor is making to establish some future prosecution? Or would Your Honor immediately go and try and gain help for that person that your neighbor just told you about? Your Honor may well go over there yourself and see, okay, this is a dire situation.
She just, I guess, as a hypothetical suggestion, she just said, Your Honor might as well go over there and check yourself. This is from a 2013 911 call. What are we doing? If you don't believe me, if you don't think my argument's good enough, just go find out yourself. What kind of argument is that? Why would you even say that?
Would Your Honor not consider that an immediate danger situation that needed addressing immediately? If someone called you and said exactly what this person said to her, Judge, I don't know.
Time machine.
But our neighbor just came over here in a panic. Somebody's in her house. A shooting just occurred, and she came over here in a panic, and her mother and her child are in there, and she doesn't know what to do. Can you go get them out? She's simply asking for assistance in what she perceives as an ongoing danger, an ongoing threat. There's not a way to perceive this as less than her attempting to gain assistance in a situation involving immediate danger. So the fact that she is telling the 911 operator what excited utterances she just heard the neighbor make, and the fact that she herself is conveying to the 911 operator her immediate impression, her own stress that she's under. So
how can I tell that? I understand the original declarants coming running and saying somebody's in my house. Okay. But how do you, the second, that's the original declarant. The second declarant, how do you come up with the fact that she falls within that particular exception?
Yes, Your Honor. She falls within two. So the first one that I would say that she falls within, Your Honor, is present sense impression. And of course, that falls under 24.8031, describing or explaining an event or condition made while or immediately after the declarant perceived it. She said, my neighbor just came over here in a panic. She doesn't know what to do. somebody, I stay over here in Summerdale. The guy that shot the guy over here off Cleveland Avenue, he is in my friend's NIM apartment, and she is panicking. She doesn't know what to do. Not she was, not she had been, not she used to be. She is now, right now, he is in her apartment, and right now she is panicking, and right now she doesn't know what to do. She's saying, right now, police everywhere out here. She's saying, was somebody shot recently? She says, yes, about 5 police everywhere out here. She says, it's over here on Cleveland Avenue, Old Hateville and Cleveland Avenue. I don't want to talk loud. People are still right there. I don't want to get myself, I don't want to get anybody in any trouble. My friend, she panicking. She is panicking, not she was, and she don't know what to do. But she got her baby and her mama in there. Not she had, not she used to be, not she was. Her baby and her mama are in there. I just tried to call her. Not 20 minutes ago I called and she didn't pick up. I just tried to call her. She cannot make it any more apparent that this is something that she is perceiving right in that moment. She dialed 911 because she can't get the panicking friend who is in her apartment with the man that shot somebody and her baby and her mama, while police everywhere out here. And I'm gonna talk low so can't nobody hear me, so I don't get in trouble. And don't tell him that you even got this call, because I don't want him to come and retaliate against me. And I got kids that he might harm. She can't make it any more apparent that this is something that she is experiencing and that her friend is experiencing as she is talking to the 911 operator. Additionally, Your Honor, I would argue that the caller, the 911 caller, under 24-8032 is making an excited utterance, because even if she is not sounding panicked to the court, her hushed voice, she is sounding out of breath at times. She is saying, expressing urgency through her words. She's relating a startling event or condition, the fact that she just came over here panicking and now she is not answering her phone. So her words are admissible under both the present sense impression, 24-88031, and the excited utterance, 24-88032, exceptions to the hearsay rule. And Your Honor, the excited utterance exception looks at, as with the present sense exception, it is not necessary that the statements be made contemporaneously with the startling event or condition. In other words, the panicking person doesn't have to be standing there panicking while she's making the call, relaying the information. She was startled by her neighbor coming to her, telling her this information. Her neighbor is startled by somebody coming in her house that doesn't belong there, that was just involved in a shooting.
Is there going to be other evidence through testimony, witnesses, and or other related 911 calls to this incident?
Your Honor, there's going to be other evidence that Jeffrey Williams was involved in this shootout in the shooting and the.
I'm talking about this particular incident on September the 11th of 2013. Meaning, because to your point, is there going to be some other evidence or some other testimony saying, hey, we were called to a blank incident about at this location. There are multiple 911 calls, or there are witnesses to testimony to bring that out, because you're telling me it was an emergency. So if there's other surrounding circumstances, as you said, I'm supposed to take a look at it in context, not a vacuum, then that might be an issue I need to kind of consider, because I'm only hearing one snippet. So is there going to be more
There are
context evidence to this particular issue?
There
And
are.
So
Actually.
what is that context you're gonna present?
A few things. As I said, regarding the 4 people who jumped out of the car, there's going to be an officer's testimony that she was chasing them in a particular direction, that one went in one direction and another went in the opposite direction. And when she went to chase them over the wall that she was chasing them over, she was called back and she had to put her attention on Frederick Prothrow, which was a person who was shot during this incident. There will be testimony, I expect, from a witness who will say that while they were going over the while they were running from the police, that shots were fired inside the car, that Young Thug or Jeffrey Williams actually had a gun, that he, Walter Murphy and Frederick Prothro had a gun, and that Jeffrey Williams or Walter Murphy was probably the person that actually fired the projectile that hit Frederick Prothro, because while they were fleeing from the police, 3 shots went off inside the car. There will be testimony that when they fled the police, that defendant Williams ran in a particular direction, which we believe will be in the vicinity of the description that this caller gave for her friend's apartment. There will be testimony that, that's it. That's the general. And then, of course, as I stated earlier, the 911 custodian of records, in explaining to me, because I had the question, how did we get from 1038 to 1308? Was there a mix-up? And she specifically said no. When that call came in, when the 911 dispatcher sent it out, when they called it out, they were then told that call is related to the 1038 call. That is a part of this call up here. So that's how they even end up. They're on one CAD report that I have, and were it not marked up, I would show the court that particular CAD report. And we do intend to introduce as evidence that CAD report that has that these are 2 related events. And in fact, the remaining reports that lead investigator Velasquez uses in the entirety of this investigation has that 911 call number attached to it. It's the entire case file is ending in 1308. So in fact, this particular case, the way that it even looks in all of the discovery given to everyone in this case, the case file case number ends in 1308, which is started and initiated by this call right here. And of course, the excited utterance exception doesn't require that a declarant express any particular emotion when making the statement. That was information that I shared with the court for the court's consideration when making the analysis, but it is not required. And
I have 2 declarants. I have 2 declarants that aren't here though, right?
Yes.
So how am I supposed to work my way through through whether or not they'll fall within both exceptions to the hearsay?
Well, as I stated, Your Honor, the first one is the caller herself describing her present sense impression, what she is perceiving.
Okay, then you got this other unknown declarant who is perceiving this from the first declarant.
Right, and what she's perceiving is she's panicked and she doesn't know what to do.
Okay, all right. I may have to hear a little bit more. All right, Mr. Steele, anything else? It's almost 11 o'clock.
And Your Honor, if the court wishes that I provide anything in particular, I will do that.
Yes, ma'am.
Oh my God.
All right, Mr. Steele, address for me, the state is focusing on the issue that in the totality of the circumstances, it could be deemed as an emergency. So how would you respond to that? They pointed out these different statements, and also in the totality of what was going on at that point in time, why wouldn't this be an emergency situation?
The state's recitation of facts are not accepted.
Well, I'm just looking at the transcript you gave me, in addition to what the state's proffer is. So I think some of the statements in here would be indicative of somebody who's trying to kind of, who may be experiencing or making a call for an emergency situation. I'm just asking you for the argument. So what would you say about that?
First of all,
Without conceding anything.
how the information comes that Young Thug was shot or shot someone, we have no idea, because that's supposedly at another time. And there's no evidence that there was a shooting in the car. There's no evidence that there are 4 people in the car that the perpetrators are fleeing from the police. It is totally up in the air. You're going to see it because it's about to come out this week before your honorable court. There are 3 people in the car. There are some people say 4. Some people say 3 people are men. 1 person's a woman. There's a woman driver, yet we have the actual person who was apprehended is a man driver. His name is Adrian Bean. This is a total fight, quote unquote. And the only person who is on any 911 call, to answer your question directly, saying anything about Young Thug is this call. And we don't even know where that information comes from and who is supposedly shot. And there's no one shot on Cleveland Avenue.
Brian Steele has to lay this out because the state, with the way that Love speaks, intentionally, maybe, I don't know. She made it seem like they have all of this other evidence where people in real time, while the emergency is happening, whether it's happening at this address or another shooting that ends up having this 911 call because someone is in somebody's house saying that they were shot by Young Thug. Love will speak in such a convoluted way that when asked, is this the only 911 call? Well, you know, other evidence, we have all this other stuff. And then here Steele has to get up here and say, this is the only 911 call relating to this address. And this is the only time Young Thug is named.
This is not a shot call. The police come out to an suspicious vehicle in that same apartment complex, Somerville apartment complex. Then Adrian Bean is driving a car, and there's an unrelated armed robbery of a man named Mr. Dotson, who unfortunately passed away before our trial, unrelated to this case. The police see Mr. Murphy flee back to the vehicle that Adrian Bean's in. Police tell him to stop, and that vehicle then strikes a police car. That's the second issue. There's nothing about a shooting on Cleveland Avenue. There's nothing about Jeffrey Williams or Young Thug being shot or shooting. And that information has to come from some source. That source is not here. So to answer your question, is it an ongoing emergency? No. No one says it's ongoing emergency except, well, no one says it because the caller says it's not an emergency. This is the only issue. It stands alone. Everything else is dealing with Adrian Bean, Walter Murphy.
What about there are police out here everywhere? My friend, she's panicking. She don't know what to do. She got her mama and her baby in there. I just tried to call her cell number. She's not responding. So how could that, or why would you say that's not an emergency without dealing with this issue of the unknown female and the statements about?
Because it ignores three factors. One, call starts as I heard you say twice. It's not emergency. Second, the neighbor leaves the apartment to tell the caller, yet doesn't call the police herself, doesn't flee the apartment, goes back to the apartment, presumably. I don't know where she really goes, but the caller says she won't answer the phone, but then on the same call, the caller says, that's them calling me. So the neighbor who's in this quote unquote panic has access to her phone. This is all of the hysteria, and I'm talking low, all that is added for flavor on Miss Love. That's why we need the witnesses here to cross-examine. So I'm not conceding that it's an ongoing emergency because I'm taking the caller for what she said.
All right. Give me a few minutes, folks.
Okay. Thank you, sir.
We're gonna be in recess.
All right, so they end up taking a lunch break. We're gonna get this quick clip. And guys, I think so I'm still gonna follow with my original plan. This argument, well, let's just play what they say right after this break when Glanville comes back. It's not gonna surprise anybody.
Okay, counsels, here's what I'm going to do. I need to hear a little more context. So I'm going to defer ruling on the issue for the time being. And then before in such a time for the 911 call to be proffered, I'll then rule upon it at that point in time. Okay? All right.
So they're going to end up calling witnesses that relate to these events over the next few days. But my plan was, and I wasn't going to initially go through all of the witnesses because not all of them are Love witnesses. Like, she likes to question some of the investigators that spoke to YSL associate. She likes to handle the stuff where she can get some of the statements in. But I showed up, I did this, I left. She doesn't really handle those. She gives them to other people. But what I think we can do, if you guys are down, we can jump to day 37 where this motion argument continues relating to this 911 call. There are a few other motions that take place that day. So if you want to watch those arguments, we can watch all of the motions arguments from that day. But then we can go back and get this whole big picture story. And I think Nancy New summarized it best. The fantastic incident with cops in high heels, a flying clown car into the laundromat that no one can agree on how many people were in the car, whether they were male or female, because of hair possibly, and Bean being on Molly and not remembering if he's ever been in a car accident. So, and for what it's worth, Walter Murphy is named. This incident, the indictment that came from that case back then, is mentioned as an overt act in this indictment. Adrian Bean was not charged in this YSL RICO indictment. And according to Aaron, it seems like back then, for the case that related to this incident, he entered an Alford plea. So what else is new? What else is new? In 2014, Bean entered an Alford plea for this. 3 years confinement, 7 years probation, no charges, and no apparent interactions with alleged YSL members. I assume that's why he wasn't indicted on this. So there we go. And let's see. I have day 37 queued up. Let me get to right where they get past their hello, welcome to court every morning roll call. Captions. Okay, court audio's not on yet. No, give us the court audio. Lawn crime. Fix your stream from a long time ago. No. Okay, here we go.
3 reasons. And I believe that this is even more now of a non-emergency event for these 3 reasons. First of all, and Your Honor, if you need it, I'm not saying you do, but if you need it, there is an exhibit. I don't remember what it is. I'm going to have to rely on the state to help me. But there's an overview Google map that was introduced into evidence that shows the relationship of the laundromat where the vehicle collided into the Somerville maybe Commons apartment where the Officer Roberson L. discharges firearm at a fleeing car that went through the gate, and then a third area. If you need to see that, I will ask the state to help. If they don't, you don't need to see that, then that's fine.
Which exhibit was that, sir?
That's why I need help.
Or Star, Miss Love, which one was that? Can we put it up, please?
Thank you.
Are you tech challenged this morning?
We're a little bit tech challenged, but I can,
Where's Mr. Kokomo?
He is here.
Don't just sit there, man. Put it up. Come on now. You can. This is a period of redemption. Come on. You lost it, man. I was gonna write your recommendation and everything.
We have all of the exhibits that were introduced.
It would be helpful if you could put it up. Can you put it up for me? Okay. All right. All right.
We're pulling it up now.
Okay. One of y'all can do that's fine. All right. I'm looking at stage 150.
Okay.
Is that the correct one? Or will this do Mr. Steele? I've got it right here. So.
Yes, I think that this is the exact one. Yes.
Okay.
So I see, and it's marked on stage 150C as in Colette. I understand, Charlie. The top part, it said the,
Listen.
I see.
He gets his ABCs and then he gives Glanville's too. That is hilarious.
And it's marked on stage 150C as in Colette. I understand, Charlie. The top part, it said the, it has a blue lock on it.
Start the center where it says Skyline.
Yes.
Laundromat,
To the
Cleveland
left.
Avenue.
Yes, to the left. I
Right.
believe, you know, everyone has their own memory, but I believe that's where the car crashes into. Then, Your Honor, going down stage 150C as in Colette, Charlie, to the center left, that is what I believe to be the
Sorry, I
Summerdale
was covering
apartment complex
the
where the
laundromat.
gate was crashed through and the Officer Roberson L. fired his discharge, his weapon. Then we have the Summerdale Commons apartment a little further down on 150C as in Colette, Charlie. in the center. That's where I believe, from what I understand, not 100% sure, but the 911 caller, unknown caller, is saying that the other frantic unknown female is. So understanding this.
I think you said, I'm sorry.
The other unknown female neighbor was coming from. So I walked this area. So I walked, if I'm right, from the Summerdale Commons apartment complex. And I know, you know, I'm not exactly sure where the person came from, but supposedly building C, and you have to go across the street, and then you have to go up the block, and you have to get into this other apartment complex. And it took me, and look, I don't know the pace, I don't know anything, I don't know traffic conditions, but about 3 minutes. But this is what I'd like the court, this is my first answer. How do we know it's not an ongoing emergency situation for the speaker? The speaker is the unknown neighbor who allegedly is then relating information to the unknown caller. And the reason I say that is because based upon what this honorable court has brought forward in testimony before it, there are now police. It's on the 911 call. There are police everywhere. That means,
Harvey.
I'm sorry.
Say good morning, Mr. Harvey. Just need to account for him on the record. Go ahead. I'm sorry.
No,
we're good. Good. Go ahead. So you have the police. They're on the scene.
So the police are on the scene, and according to the 911 caller, Your Honor, the police are everywhere. And
but wouldn't that lead or cut toward the face of their police everywhere to say it's a more an emergency situation because you've got
There's already
shots
police.
fired. You've got I would say arguably a car flying into a building is a pretty significant event. Wouldn't you agree?
Yeah.
Then okay, on a regular day, and then you got shots fired. So wouldn't that lead to the emergency situation of what's going on in that particular area?
Whose emergency? That's the issue. Who is the person? They're not here to be cross-examined. I cannot, and Mr.
It's the caller's it's the caller.
Exactly.
Okay.
So what I'm trying to say, and I thought a lot about this for the honorable court, because that's why I brought up, you asked me this last time, and I don't know if I gave you a full, fair answer, but we start with, it doesn't come in.
I know that's just how Steele speaks, but him saying full and fair answer is kind of funny.
That is the premise. It's a constitutional clause issue. And then, of course, the secondary barrier is a hearsay issue. So it has to be the caller who, in this case, has to stand in the shoes of the unknown neighbor who is experiencing the supposed emergency. So the emergency is for the neighbor, the unknown neighbor who is in building C allegedly. I'm not conceding any of these facts, by the way, but
I know.
for purposes of this argument. Your Honor, that means mandatory by this map, and if it's wrong, obviously, you know, somebody tell me, but I'm using this map, and I'm using my walk when I went out there.
Okay, of course, I can't consider what you did because that wouldn't be evidence.
Okay, then
okay, but
I'll ignore that.
Okay, but just based on the map itself and the testimony of several witnesses, it's not that far from the laundromat. I'll give you that much. It's not that far from the laundromat to the Summerdale apartments or the Summerdale Commons.
Well, but what is in there in that distance, whatever that distance is, far, not far, what is in there? Police officers. We know that on the 911 call. We know now where the police officers are because you heard the Honorable Detective Velasquez say that he is in the Summerdale apartment complex. Robertson, I apologize to the gentleman. Officer Roberson L. never leaves that area. His patrol, his teammates left to follow the 2004 Nissan fleeing Altima red vehicle. Other units responded, including crime scene. It went out. You heard from Detective Velasquez. The entire city got the signal, and I don't remember what it is, but it's the police officer, God forbid, shooting or needs help, needs assistance. So what happened is you have to, what the law tells us, the rules tell us, the principles tell us, is you have to find that the confrontation clause is satisfied because this is an ongoing emergency for the neighbor. Your Honor, the neighbor passed law enforcement officers on her way to the unknown caller's, 911 caller's residence, because the unknown caller said that she is in the Summerdale apartments. And the police
But look
are there.
at Pitts and Crawford versus Washington. You know, in Pitts, Justice Sears, writing for the court, our Chief Justice at that time, says, we hold the Confrontation Clause is not violated, whereas here, the caller's primary purpose is not to provide evidence against the accused, but to thwart an ongoing crime or seek rescue from immediate peril. So why wouldn't you got these two callers here. The one who's talking to the woman that is, wants the police to come immediately because somebody's in her house. So why wouldn't that necessarily fall under that particular thwart an ongoing crime or seek rescue?
Okay, that was my second point, but I'm going to go there. The second point is it can't be an ongoing crime to seek rescue. The caller, excuse me, that's wrong. I'm sorry. The female neighbor leaves her apartment. She then, according to this 911 call, is going back to her apartment. Nobody who is under the siege of an emergency and panic and frantic and something terrible is about to happen walks by law enforcement twice to get to the neighbor and then to get back home and goes back home.
But we don't know where the law enforcement is. I mean, we don't. We know that there is a law enforcement presence, but we don't know where the police are. I never heard any testimony about that.
You do, because it's in Mr. Williams' Exhibit A.
I've got that. Exhibit A. I've got that. But it says, yes, about 5 police everywhere out here.
Right.
But
That's the call. The police are there. So then what happens? If it is this ongoing emergency, I'm going back to number one, but I promise you, I'm trying to explain the seek rescue ongoing emergency just to finish number one. That means that the unnamed neighbor passed all of the departments to go to her friend. There are other doors there. There is a cell phone that, according to the 911 caller, was not taken away from the neighbor. The neighbor did not seek, and this is your question, rescue, did not seek police assistance or any assistance from an ongoing emergency. We are relying on the caller, the unknown caller, who is not panicked and who states immediately, this is not an emergency. We need to cross-examine both of these people. I have neither one to cross-examine. So the fact that the police have an ongoing emergency.
okay, well, I get to that only if I decide that first one is the primary purpose to call testimonial.
It can't be, in my opinion, it can't be non-testimonial because it is reporting an
Well, if I
event.
decide that it's an emergency, my analysis stops there, right?
This is well,
Okay,
no,
Is that,
because
if I decide at this point in time from the facts and circumstances that the primary purpose for the call at this point would not be for purposes of prosecution, then it's non-testimonial and the analysis ends. If I determine it's testimonial, then we go to step 2 to decide whether or not either the unknown speakers would fall under any hearsay exception.
I Minister, all due respect, I disagree because remember, Confrontation Clause also can have components. Even if you find this is an ongoing emergency, which I'm not conceding, but if the Honorable Court finds that, you then have to parse through the call to find what is testimonial and what is non-testimonial.
I thought my analysis ends if I don't decide. Mr. Steele, I like you to, because sometimes you kind of shave things down. Is it the law that if I find that this is non-testimonial, my analysis stops? I want you to answer me that for me, because I don't want to be mistaken as to the analysis.
No. Can I read you from Pitts? It's a direct quote. I assume that you have.
I have Pitts, yeah. I have Pitts in front of me.
So, Your Honor, this is the second full paragraph from the very end of the opinion where it says, judgment affirmed, all justices occur. Go up 2 paragraphs from there, the second paragraph from there. And it starts with Amy Pitts asserted her marital privilege. Okay. Did not testify at trial, thus rendering her unavailable at trial. The trial court admitted, and this is what I'm referring to, Your Honor. The entire recording. And we find no error under the present circumstances. And this is what I stress. However, we do caution that in certain circumstances, a caller may shift from a non-testimonial statement into a testimonial one. When Amy Pitts explained to the operator that her husband had violated his parole and that he was, quote, wanted, end quote, she came close to providing testimonial evidence.
I would agree.
Because the crime was still ongoing, and I stress this, in her presence, immediate presence, however, the primary purpose remained the prevention of immediate harm to herself, and her statements regarding her husband's parole violation were made to illustrate the prior difficulties that made the current situation such a dangerous one.
All right, it says at the bottom, in future cases,
Yes.
trial courts must decide whether a caller's primary purpose is shifted in such a manner as to render portions of the call testimonial in nature. So,
And should, so I didn't mean to interrupt.
no, and should selectively redact portions of the recording in that case. So I got to decide if I decide that. But at this point, I don't see anything in this transcript which would indicate that it's shifted at this point.
Well, so what is first of all, we're not dealing with the Amy Pitts of the world. We're not dealing with the person under the stress of I'm not talking about hearsay, of the ongoing emergency. We're dealing with a third party caller who does not see any of this.
No, but the third party caller is right next to the person who has apparently some particular person that may or may not have been involved in this particular circumstance, but in their apartment.
No.
And wants the police to come to get them out of that apartment.
No, if they wanted the police to come.
Well, that's argument. That's for us to decide.
No.
If I decide that, well, then that jury will weight it accordingly.
But no.
Yes.
What happens is.
You may not like it, Mr. Steele, but that's the facts of where we are.
I'm just trying to explain. If the caller's removed, just for a minute, because the caller's not right next to the person in need. The caller doesn't see anything. The person in need, allegedly, that person's not even in the vicinity when the call is made. That person goes back to the supposed emergency.
I have no idea, baby. I promise I can tell you that I don't know. The only thing I know is she came running. She came to my house and told me the guy that shot someone named Young Thug or whoever supposed to be shot someone, and that guy is in her house. I don't know y'all can do that. I'm trying to get her out of the house, but she won't answer her phone right now.
The person who the caller is talking about already left the house. That means, if you take that as true, that the caller went back into the house.
But Mr. Steele, you got to look at the totality of the circumstances.
I am.
Of this particular incident, which I've heard now 3 or 4 folks testify about. And it's not in a vacuum. It's got to be looked.
Remember, we jumped. The first half was day 32. This is now day 37 that they're continuing this evidentiary issue because the witness that's going to talk about this specific 911 call is set to take the stand.
That in the totality, you got a car coming into a building, you got a crashing of a gate, you got a shooting, and you got 911 call.
Car coming in building's not mentioned.
But she doesn't know that. But
Exactly.
still. She didn't know that, but she's at but it's got to put context. Remember, she's at the trail end of somebody that has fled. If the facts, in fact, that's what the court surmises. Now, whether the jury believes that is another thing. But from the facts, it is reasonable to conclude that somebody ran from that particular scene into those apartments and they were shot. That's what's reasonable under the circumstance.
Who was shot?
We don't know.
Exactly.
But that's for them to decide. No. That ain't for me to decide. That's a weight versus admissibility issue.
If we can cross-examine.
Oh, well, no, it's kind of like,
yes.
Ordinarily, yes, but this is one of those circumstances that I'm sorry. I'll make a ruling and we'll see what happens.
Well, I know what will happen if you make a ruling. I'm going to follow your ruling, but
I know that, but it bothers me that you won't be able to do that, but that doesn't make it not inadmissible.
This is an un-American trial to allow in a.
Why now? Why you want to make it un-American? We all follow the.
Is this the precursor to the communist Russia?
Rules of evidence, Mr. Steele. Okay, some of them Some of them, work out fine, but remember, when you admit evidence, the overarching thing of our rules of evidence is the admissibility of evidence and the highest and best evidence for us to use. Now, depending upon where you fall on the continuum, sometimes that evidence may cut for you and may cut against you. I don't disagree that you don't have a right to confront, but and Crawford and his progeny, guide my direction and my analysis. So that's what I'm going to do. I'm not saying that I don't disagree with you about anything about the fairness or otherwise, but remember, I'm the referee. So
I understand. I'm not questioning the soundable court.
No, I understand. But I want you to understand, I get it, but these are the facts I have. But we may disagree, but
let me talk more about the facts, because I keep feeling like I'm not articulating and I'll just going to piggyback on what the soundable court just said. The overarching purpose of a trial is for the jurors to have the best and highest evidence. The overarching way that we get the best and highest evidence is through the crucible of cross-examination. That is not only statutory, but constitutional. And what we have here is you potentially will find an ongoing emergency. If you find that, and I'm not conceding, I'm going by what you said, how is it, and I'm answering your question, when you said, if I find that it's an ongoing emergency, am I done with the confrontation clause? And I said, Your Honor, no, because the part that you just read, that would have to be redacted. How does that go to an ongoing emergency? By naming Young Thug, how does that go to an ongoing emergency? The caller doesn't know Young Thug. The caller says, the way I listen to it, Young Thug may have been shot or shot someone, however the listener hears that. But she starts with, the question is, so who was shot? I have no idea, baby. I promise you, I can't tell you all that I don't know. The only thing I know is she came running. She came to my house and told me that the guy. Now, why is that?
Because you got a present sense impression, or you have a or excited utterance of the person who she runs to the house, and then a woman who is conveying this is in a present sense impression as well. So now, whether or not she told her that or not, that's
important, because
I know it is, but that's for them to decide, because this particular circumstance, it's going to go to weight. It's whatever the jury wants to consider it as. It just is.
Then why don't we just let in all recordings?
Because I can't do that.
Without cross-examination.
Because I can't do that.
You might be doing it here. The Honorable Judge Glanville, look at that. Somebody named Young Thug, or whoever that's supposed to be. That doesn't go to weight. That is testimonial. That does not go to the ongoing emergency. The ongoing emergency is
but that's not for the purposes of well, that's one of the things I got to decide. So I'll have to decide that. I'll ask the state what their argument on that is in terms of whether or not that shifts into a testimonial, that statement. But it's
that's what I'm asking you. I disagree. I think the whole thing's testimony. But when we get to that part, and that's the only part that is really at issue, because if you were to redact that,
his name.
Exactly.
Just his name?
Right, because if you redact that, if you think about it, then it's...
So if I said shot someone or whatever that's supposed to be.
Yeah, because, and you've always... I've heard you say this multiple times in this trial. You said, lawyers, I need you to give me the best information. I don't want to do this twice. If this is admitted, and if I am correct, it's confrontation clause, it has to be harmless. It's a constitutional issue. It has to be harmless beyond a reasonable doubt. That's what it has to be. It's not like it's just a harmless error analysis. We have 191 acts, and it has to be harmless. This piece of evidence has to be harmless. So you told me, that's why I tell you about the juror. I don't know if that juror should have been excused or not, but I'm telling you, I'm not waiving the issue. I made that clear.
So between the clip that we watched and now is when juror like 204 or 402, 204 was excused. She moved out of county. So she ended up being excused. She had to speak to the judge.
I told you about the speedy trial right. I told you when you said it's going to be, we're going to do it in the next term of court. I said to you, Judge, you know, I have to tell you this. I feel compelled to tell you this. I think there's a possibility, I may be wrong, that
It's argument, ma'am. So don't worry about it.
all
right.
Yeah, I have to tell you, I think we have to pick a jury by the state, and I'm not waiving the issue. And I'm telling you the same thing now. The
Weird wording. It's argument. Don't worry about it.
fact that it says somebody named Young Thug or whoever that's supposed to be, to me, is the most problematic part if you let it in. And I'm just going back to what you just discussed in Pitts.
If it's problematic, that's why we have trials. But I understand that. So you're telling me, it might be a fatal error. But
yes.
And look, Mr. Steele, I've been a jurist for 28 years. I've had my homework graded plenty of times. If that's the case and I make an error, then I'll live by it. But
it's the point is to not make an error.
I know, but I make it based upon the best decisions I can make at that point on.
But I go back to
I understand what you're saying. I do understand what you're saying.
I go back to Pitts. You know, in Pitts is totally different. We have the frantic caller who gets hung up on twice by 911. Third time 911 calls back and she answers the phone and she's giving information that is not just, I need help. Here's my address. She then goes into, my husband is on parole and I forget the other one, but there were two things. He's on parole and he's doing something else. And
he's wanted. He's violating his parole and he's wanted.
Okay. And the court went out of its way. It's at the end of the opinion. They already made the opinion. And they said, we are warning or we remind or, you know, in future cases, the courts must remember. Okay, here it is. However, we do caution the Honorable Supreme Court that in certain circumstances, it may shift. And here, what I'm saying is this is a colossal shift. Why do we need Young Thug or somebody, whatever the quote is, somebody, or excuse me, Young Thug or whoever that's supposed to be? That is not saying my husband is wanted, he's on parole, you get here immediately, which they found is close issue. This is, I don't know if it's Young Thug, it's somebody, and therefore, if you remove that, it is still which you're finding, I'm not conceding, Your Honor. It's still, okay, get here for the emergency. And the state can argue. They're going to have other evidence, by the way, that Mr. Williams was in the car, because you haven't heard it, but I don't mind telling you, Mr. Bean will be testifying. He made prior recorded statements. So they'll have the evidence. I'll have to deal with it. But to bring in two people, voices, on a recording of 3 minutes plus seconds that I can't even touch these people. I don't know who they are. That seems to me to be the un-American I was talking about. I'm not trying to be insulting to anybody. I'm fighting for what I believe is the law. I mean, I believe in this. And I believe that to put that in, that recording, is not only repugnant to what we stand for, it is right here in Pitts. The state doesn't have the same facts, and you can't find the facts. When this honorable court started talking about the statutory hearsay, present sentence, repression, excited utterance, you're taking that from two different people who are not going to be here. This is hearsay within hearsay with a confrontation clause, non-testimonial component. And what I'm arguing respectfully, is it's all testimonial component. So I have, like, you know, the way my brain works, I have all these gigantic barriers and we let it in. And why are the rules there? Because then innocent people get, God forbid, convicted. This has been tested. This was in our Constitution and then statutorily. This is why we don't allow in non-cross-examined pieces of evidence. And this is a dynamite piece of evidence to me because I can't do anything with it. If they had the callers here, I don't care. I do not care. I wouldn't even make an objection because they're going to be on a witness stand. It's like what I said about the jail calls. If they call Adrian Bean, I asked you to redact them. The state correctly said we may not need them at all. We may not even need those jail calls. We'll have to see what he says and then put it in context. And your Honorable Court said, okay, we have to defer that motion. I'm fine with that. I'm not ever asking for the jail calls to be excluded. I'm asking for the rules to be followed. Here, I'm asking for exclusion because I can't touch any of these people. And as the court knows, you've seen more trials than I've been involved in. You don't get the facts from a 911 call. You just don't get the facts. And then, the state came up last time. I'm not saying you remember, but they said, this is like the person who saw somebody being arm robbed in the alley and then goes across the street and makes a quiet phone call and doesn't want to sound panicked, but they're panicked. This is not like that because the 911 caller didn't see anything. She's relating information that she got and she starts out, and I'm just hooked on it, Your Honor. I don't understand how my brain doesn't get off it. It starts out with the 911 call saying, what is the address of your emergency? It's not an emergency. I can't write that out. I don't know. Maybe I'm just too, I simplify everything in my life. So maybe I'm just too simplistic, but I can't get off. It's not an emergency. And it's not an emergency because now that we have some facts, the caller states that there's police everywhere. The neighbor, the supposed neighbor, I don't know if there is a neighbor, but the supposed neighbor supposedly walks by police officers at least twice, leaves the house. She's not being held in the house. She calls, the caller is calling, the caller relates to the 911 operator that the supposed neighbor calls during the 911 call. She states that's them calling now. So, Your Honor, when I put up all these rules that it shouldn't come in because the witnesses aren't here, that's where we start. These are exceptions that the state wants. And I can't get out of it. And then, I listen to the demeanor. I listen to this call a lot. That caller's demeanor is not panicked or frantic. It is relaying information that she may not have, she may have, it may be right, it may be wrong. That's why I can't get over it. And when if the Honorable Court disagrees with everything I'm saying for the Confrontation Clause, and you find it to be non-testimonial, then I still come back to Pitts, because it tells us it's not so simplistic of it's a head or a tail, admit it or exclude it. You have to look at redacting. And I don't know how that shot somebody named Young Thug or whoever that's supposed to be shot somebody. How is that non-testimonial? Now, if it was that Young Thug got shot or Young Thug shot somebody and that guy's a brutal assassin, he is known in the community for murder, he is a villain of villains, then I think it's closer to Pitts. I still think it's away from Pitts because it's not the caller. But then it's closer to Pitts because, Your Honor, at that point, you're giving context. Why is this go to the emergency? But to say simply, she came running, she came to my house and told me that the guy that shot somebody named Young Thug or whoever that's supposed to be, that means she doesn't know it's Young Thug. So, and that's not going just to trustworthiness of, which I know we have to get to, of excited utterance or repeating an excited utterance. That goes to, or whoever that's supposed to be. She doesn't even know who that is. What if it's not Young Thug? This Honorable Court may be letting in an unconfronted call with two people. And what if the witness was here and she said, no. I don't really know if it was Young Thug. That's what someone else told me. So the point I'm trying to make to this Honorable Court is I do believe that's testimonial, but if the court disagrees.
Can I give you, excuse me, 1 second?
Of course. Can I just step back for 1 second?
He needs a break. Look at them still going. Oh no, show us. No, show us the table. No tie chart.
Sorry.
Oh, no, I'm sorry, Mr. Steele. Go right ahead.
So The three reasons that, to answer the court's original question, is again, and I heard your potential leading. I'm not saying you made a decision, but
I haven't.
that it may be an emergency. I don't believe the emergency is created by the circumstance. The emergency is created by the caller, or in this case,
I fundamentally just disagree with that. Stuff you have going on would be an emergency in the court's opinion. But the question there becomes is, I got to make, like you said, I got to make a decision whether or not to call this testimonial or non-testimonial, purpose of the call. And then depending upon that, then I'd also have to decide as in Pitts whether or not any part of this conversation shifts from being non-testimonial to testimonial. So you are correct about that.
So I thought, Mr. Matthews comes to me and states, hey, there's this guy in my apartment, can't get the guy out, has a gun.
Has a what?
Has a gun.
Has a gun.
Has a gun. But Mr. Matthews says, I'm going to go back to the apartment. Walks by all these police officers both ways. I call the police and I say, it's not an emergency, but here's what's going on. The reason I give you that is, but I don't realize that anything happened with a car slamming into a wall and one person supposedly escaped capture. I just don't realize that. So the emergency is really not have anything to do with the capture. The emergency has to be with Mr. Matthews. Now, if Mr. Matthews carries the day and he says, hey, that's an emergency, and the court finds that, that is one layer. Then, of course, I'm the one making the call. I'm not going to be present either as a witness. So I have to be in that zone where it's non-testimonial. Now add, and I'm not sure, but I believe that it was the Honorable Max Shard who was in there with the gun. But no information about Max Shard, his background, why and then I say, and I don't know. How is that piece, regardless of everything else, how is that piece about Max Shard not anything but testimony? It goes to, you're calling 911. You're not talking to somebody else. You're calling 911. That is, and by the way, the perpetrator may be Young Thug, may not be Young Thug, by the way, but maybe, and we can't cross. So those are my reasons, Your Honor. I just can't get by the fact that the supposed emergency victim walks by police twice. And I don't think that we could just say, well, maybe she didn't see the police. If we're looking at the totality of this 911 call and then what the police officers say, the 911 call says there's police officers in the area or everywhere, whatever the right word is. In addition to that, you asked about, this is near the place where the incident occurred. There's no evidence the caller knew that. The car slamming into the wall.
I have to know that, but it gives context in terms of why or how you got, a jury may decide to believe that, hey, from the testimony that's been deduced so far, that this person actually ran and then posited themselves into this apartment complex. And that's for them to decide. But it does give context about how somebody got from that crash site and then went into an apartment.
That's testimonial if you used Young Thug.
Okay, I understand. Okay. All right. So anything else?
Well, we didn't even get to the other part. You want me to do that now too?
Sure. What's that?
Well, I've been focused on the constitutional right. And then of course there's the present sense impression / excited other.
Well, you can finish that, but I have to, because if I decide that that some part of it is non-testimonial and some part of it is testimonial, then I will excise that particular, that sentence, okay, or that name, I should say. I don't see anything else in the transcript would be testimonial.
I can see that if you make those findings, yes, that would be the one. All right. Action. Yes.
Okay. I'll see whether or not, based upon the state's argument, if I need to hear more argument, I'll let you do that.
Okay. Then I'll reserve the, if needed, I'll reserve the statutory ground.
Okay.
All right. Thank you, Your Honor.
Okay. All right, Ms. Love.
Your Honor, I'll start out by being clear. It is not error. There is no error in admitting the entirety of the call. The first words out of Mr. Steele's mouth this morning were in relation to the frantic 911 caller. That's what he said, a frantic 911 caller. But I'll get to his last argument regarding testimonial and not testimonial, because the confrontation clause is the first assessment that the court has to make. Mr. Steele's argument is that had the caller said, Young Thug is known for committing crimes, all of this, that would be closer to Pitts. In fact, that is the type of information that would be testimonial. The fact that this caller is giving to the 911 operator all of the details that she has gotten from this panicked neighbor who came to her in an effort to get the police out there. The fact that she says Young Thug or whoever is in her house just shot somebody. That is information that is a part of the ongoing danger that she perceives the neighbor as.
Let's say I do that. Let's say I agree with that. But wouldn't Pitts tell me that I've now shifted from, or potentially that particular portion would shift from being non-testimonial to testimonial? Because remember, we have no way to, because it is a specific, like, hey, this dude, Young Thug, is in the apartment. We don't even know the context. We really don't. We don't. But why wouldn't that be testimonial, that particular piece? Because that's what Pitts tells me I need to do, is that the courts have to be careful. Their primary purpose is shifted in such a manner as to render portions of the call testimonial in nature, and should selectively redact portions of the recording when that's the case. Because the entirety of the call remains the caller's effort to get the police. I disagree, because that's not what Pitts tells me I need to do. Your Honor, what I'm saying is that in Pitts, the person who called in Pitts, when she began to give, and just to say that when in Pitts, they began to speak information about the background. Plus, you didn't have a third party emissary. You had the actual person or who was being perpetrated against actually calling. So as we're focused on the confrontation clause, it either is testimonial or it's not. And whether it is testimonial, I would agree. And whether it is testimonial or not depends solely on the purpose for the information that is being given. However, we do caution in certain circumstances that a caller may shift from non-testimonial statement into a testimonial one. And then they talk about what Ms. Pitts having explained to the 911 operator that her husband violated his parole and he was wanted. So how do you distinguish that? Because the information about her husband being wanted and violating his parole, and even that they did not consider to be testimonial. That is closer to testimonial than the person saying, this person is in her house. This person is in her house having just shot someone and she is panicked and is in there. Her mother and her child are in there. The testimonial portion, the parole portion is not at all akin to her saying, my husband did this. The fact that she is saying it is her husband who committed the act, who is committing the act, is the part that is not confrontational. The fact that she names the fact, non-testimonial, my apologies to the court. That's all right, sorry. The fact that she names the perpetrator or who she believes to be, the fact that she is giving information to the police to get them there and giving information to help them respond to this ongoing threat that is in her neighbor's home. They have to have this information in order to be able to properly respond. They would not need the information about the husband being on parole or being wanted. But even that, the court in Pitts decided was not testimonial. That's how you know that this information that this caller is giving the 911 operator in this case, this information is non-testimonial, because it is even more of an effort to get the police to respond to a threat that is in existence at that time. The information as to who it is only akin to the caller in Pitts talking to the police about what it is that her husband is doing. Her husband is doing a thing at that moment, not he is on parole or is wanted. But they make the distinction in Pitts that because the crime was still ongoing, right, in her presence, however, her primary purpose remained the prevention of immediate harm to herself. And the statements regarding her husband's parole were made to illustrate the prior difficulties. It made the current situation such a dangerous one. So that's how they distinguish, and they say that the entirety of the call is they authorized it, but they do say that that courts now must decide what the caller's primary purpose has shifted in a manner to render portions of the call testimonial. So that's what I'm kind of resting with at this point in time. So I think a little different than Pitts. Pitts, you've got, like I said, person directly under the unfortunate situation of somebody who's committing violence. And Your Honor. And clearly committing violence. In this particular circumstance, you got intermediary who's relating information that is going on. So I have to kind of look at that a little more carefully than, because each individual situation is different.
And to the court's point, when the court speaks about the threat, the ongoing threat, for the caller, the ongoing
In
threat.
Pitts, in Pitts or in the circumstance at hand?
When the court spoke about the ongoing threat that the court, when Your Honor spoke about the ongoing threat in Pitts, that the court addressed the caller attempting to have the police respond to. It is akin in this circumstance when the caller is saying, I know she came to my house and told me that the guy that shot somebody, whoever he's supposed to be, is in her house. So I don't know how y'all can do that. I'm trying to get her out the house, but she won't answer the phone now. That is the ongoing emergency. And just to give a little bit of context, I heard, but I don't believe that it is anything at all that any evidence has come in to suggest. I heard the suggestion that the caller walked past police twice and gave him or didn't give him a phone or something like that. But just to point out where we are, Your Honor, and just to make certain that the facts are crystallized in the record. Officer Black testified, just one second. I'm pointing on the screen. There are two separate phases to this apartment complex, Summerdale. The phase where the red dot is, Officer Black testified that that is the phase in which the car crashed, in which the shooting first occurred. Then Officer Black, we've heard testimony that the car went through the yard just across the street diagonally. And we have other pictures that I can show to the court that better reflect what took place. The court can see in State's Exhibit 129, Charlie Alpha. Can you put that up on the screen?
I feel like she's running a mini bench trial right now.
And I'll just hold it up for the court. That there is a dearth of shrubbery. We can see that Summerdale Apartments, the one phase is here.
Who can see this image? Look how far away she's standing from the judge, and she's like, "Look at my paper. Look at this photograph." Oh.
You can go ahead and keep the overview up. One phase of Summerdale is where in 129 Charlie Alpha, I'm holding up to the court. It's
You can put, oh, here it is. Okay. It's still 150.
Go ahead. I'll use 150 and then I'll go to 129 Charlie Alpha. If you would point on the screen, Mr. Atkins, to the first phase of Summerdale Commons, where the car and the shooting first took place. After the shooting took place, the car went across the road into the laundromat. After that, the occupants of the car, two of them jumped over a fence. One went left, which is the area where the arrow is, and one went right. And those trees, as Officer Black testified, there wasn't that much greenery. What it looked like is on 129, more like 129 Charlie Alpha.
All right, let me see that one. 129.
Can you put that on the screen?
Love is like, I'm using your preferred alphabet, Glanville.
Do you have a 129 Charlie Alpha?
Take a little time. He takes it, pulling it out, it takes a couple minutes to pull up.
And as that is coming up, Your Honor, I will say to the court that the court has heard the testimony that the area of the phase of Summerdale Apartments where the shooting first occurred, that phase is identified by numbers. The buildings are identified by numbers. In the second phase that the caller was calling from, the court heard in the 911 caller, we're in not the old Summerdale, the new ones, and that it is in building C. Officer Black testified that the second phase of Summerdale Apartments, the ones that
Summerdale Commons?
Yes.
Okay.
That second phase, those buildings are identified by letters, and the letter C, the building C, is exactly where the caller identified it as being. We're in the.
I understand.
So the idea that the panicked neighbor went past police officers twice is a fiction being made up because the police officers are in the first phase.
They're in, I need to take a look at 29C. I mean, 150.
I'm going to just go ahead.
Shannon says, "Hi, everyone," and then says, "Love reminds me of a laxative. Is it because of the color of the blazer or is it because of the behavior?" Because it could go either way. Thank you for the 2 and good to see you. Happy Friday.
Put 150 back up if you can. I'll take a look at 29C, please. Put 150 up, please, again. All right, so starts at Somerdale Apartments, and then it goes to Skyline Laundromat, and then two of the alleged suspects end up at Somerdale Commons. So
One of them
One
is,
you say, so the one that is in Somerdale Commons, that's where the 911 call is coming from?
yes.
So when she's saying police, or she's identifying police, where are those police? Do we know?
The police, the evidence that we have is that the police, they were in the first phase of Somerdale Apartments. And they are also down at the Laundromat, because remember, that's where
Yes.
Adrian Bean gets hit.
I don't know that yet, but, okay, I don't know that yet, so. But
Right, the name, well, we'll say one of the people in the car gets hit. That's what the testimony has been so far.
I haven't heard that, so, but anyways, of note to me, the court is your caller, the 911 caller is calling from Somerdale Commons.
Yes.
All right, and then stage 129 Charlie. Charlie Alpha, I should say. Okay. All right, so what were you telling me about Charlie Alpha, 129 Charlie Alpha?
So 129 Charlie Alpha shows the entrance to the apartments where the shooting occurred.
The first phase.
Correct.
Okay, all right.
And the testimony came in that in 129 Charlie, I'll refer to the one on the screen since we don't have 129 Charlie Alpha up.
I have it in front of me though.
Okay, Alpha is the one she drew on. So if the court comes out of the phase one and turns to the left, the court will be going towards the Laundromat. The testimony came in
Laundromat on the left or the right? So, and the one you have up, Charlie,
on where the arrow
where
is.
the red car is?
Yes.
That's where the laundromat is?
Yes,
I understand. Okay. That's not that far down the road.
correct. And then if you turn to the right or the other way, if you go up the other direction, is where the second phase of Somerdale.
So the Somerdale Commons is.
Yes.
Okay.
Yes. And in telling the 911 operator, I'm trying to get her out the house, she won't answer her phone. We don't know where she went, what has happened to her. The information that they're given is to inform the police. This is about someone who is alleged to have shot someone. And what the court has heard is that 2 people were shot, 2 people were bleeding. We have blood. We have that a shooting has occurred. And all that this caller is doing is trying to relay the information that will get the police to respond immediately. Come now, this person here, the information, the excited utterance that my neighbor gave me is that somebody named Young Thug or whoever that's supposed to be shot somebody and he is in her house. That is the excited utterance that I perceived. My present sense impression was her giving me this excited utterance. Now I'm trying to get her out of the house and she will not answer her phone. That is non-testimonial. It will not be error for the court to admit this.
Well, I say that Mr. Steele indicated that the problematic issue is the naming of the particular individual.
And that would be akin to a 911 caller saying, my husband did this or the gunman did that. They have to give some information to help the police address what she perceives.
That would be if she was actually making the call. You don't have her making the call. You have her communicating that through a third party.
Correct. But again, we're in the testimonial versus non-testimonial portion. Correct. And her purpose for giving the call and all that this paragraph where it says unknown female, all that paragraph is trying to get, she even ends that portion of her commentary. I am trying to get her out the house. That is the ongoing emergency. The circumstance.
This is a 3-minute phone call, and we've been watching arguments about it for about 2 hours, with most of the time at least somewhat sped up.
Surrounding, she doesn't know about. All she knows is that this person allegedly shot somebody and is now in her house. In other words, he's dangerous. Perhaps he has a gun. The circumstances the court is aware of that she didn't have is all the testimony that the court has heard. And from understanding the court's instruction and directive the last time when I stated to the court, I came and I said the court will hear the circumstances surrounding that call.
And that's been presented. I understand that. I just have to kind of, in order to make the best decision, I have to follow what Pitts tells me. And that would be, I've got to be able to parse out these particular statements. Do you have any other case law which would indicate, or this parsing that Mr. Steele mentioned?
Yes, Your Honor. So in Carter versus the state, 315, Georgia 214, where the Georgia Supreme Court addresses the confrontation clause specifically at 221, page 221, the court says.
You give me a second. I got to get to Westlaw. So.
Yes. May I tell counsel for the defense what it is?
Oh, yes, I think it's, I just lost it here.
Carter versus the state.
That's the problem. I don't too much.
It's Carter and it's 315 Georgia 214 at 221.
Oh, there it is.
2022.
Okay, I'm looking at Carter. All right, I've read the portion of the opinion under B confrontation clause. So
Yes, Your Honor. And
I
so,
understand.
so that is what we are saying here. The non-testimonial statements, as the court said in Carter, non-testimonial statements include statements made to law enforcement that are intended to describe current circumstances that require the immediate police action. And that is exactly what she's doing.
I would agree. I have no disagreement. But the statement itself would be testimonial.
So the statement itself, the court in this particular case, the court said, if its primary purpose, it is only testimonial if its primary purpose is to establish evidence that could be used in a future prosecution. And in Carter, just at above page 223, so at 222, here the trial court did not commit error, much less plain error, by admitting Mann's statements into evidence, as her statements are non-testimonial and therefore do not trigger the protections of the confrontation clause. Rather, the record shows that Mann specifically requested that Carter not contact law enforcement because she did not want to incriminate appellant. Our 911 caller wanted to remain anonymous. She said, I don't want to get anybody in trouble. I don't want to get myself in trouble. In Carter, the court said Mann's statement to Fox, indicating that if anything ever happened to you, appellant did it. And here she is naming the person, just like that panicked neighbor did. She named the person. If anything ever happens to me, Carter did it.
I still think you got to look at this from the standpoint of you got a third party that is communicating this particular statement.
And in this case, Fox is the one communicating Mann's statement. Fox is the one that said, Mann told me, if anything ever happens to me, Carter did it. And in our case, we have a 911 caller saying, my panicked neighbor told me Thug is in her house.
A little different down this kid.
Said that something about Thug and shot. Thug, whoever that is, and shot.
Situation. And it's just fundamentally a little different from Carter versus what we have here.
Your Honor, the analysis, I understand that the defendant would rather not have his name mentioned, but the fact that
that's not the point, Ms. Love. The point is, Pitts tells me that I have to, then Chief Justice Sears makes it very clear. Courts are to determine and take a look at 911 calls in particular about some things that may be non-testimonial and testimonial. So that's kind of what we have to kind of do in this particular circumstance. And that's why I'm kind of concerned that, and especially since it's being communicated to a third party, but it specifically names Mr. Williams in that particular regard.
And if I may, Your Honor, when the courts, every case that we look at, there is never a word by word analysis. The court looks at the entirety of the statement to determine if at some point it turns testimonial.
Well, you're right. And that's what Pitts tells me to do.
And
so I have to kind of look at it from that standpoint.
And the intent of the caller is what makes the statement testimonial or not. If the caller intends.
But some portions of the statement, remember, that's what Pitts tells me to do. I have to look at whether or not some parts of that statement are testimonial.
Right.
And that's kind of that's what Pitts directs me to do.
And it's only testimonial, Your Honor, if its primary purpose is to establish evidence that could be used at a future trial, in a future prosecution.
Well, I would think that naming a potential suspect would be evidence useful in a prior trial. I know you're shaking your head over Miss Hilton, but that's, no. I'm sorry, okay? That's just the facts.
Your Honor, what I was saying was
that's just the facts, okay? Just like I told Mr. Steele, evidence may not cut, it is what it is. It cuts both ways. So it's kind of like, this is what our highest court tells me I have to do. Now, you all may disagree or not like it, but that's what I got to do.
I agree with Your Honor, absolutely. And all that I'm saying, Your Honor, is that every single case that we have regarding the confrontation clause, in every one of them, a person is named. The person is named that is alleged to have done the thing that is causing them to make the statement.
It depends. Like I said, it depends on, you have to look at, Crawford tells us in his progeny and even in our jurisdiction in Georgia, you have to look at the primary purpose of the call. Was it testimonial in nature? Was it made for the purpose of gathering criminal or fostering for use for trial or for potential criminal prosecution? There are certain exceptions to it, and the emergency situation is one. But even with the emergency situation, Pitts tells me, got to look at whether or not some of those particular statements are in fact testimonial. So even if I believe, first I got to decide whether or not it's testimonial or not. And even if I decide it is non-testimonial, it's an emergency, then some of then I have to look at, and Pitts directs me, I got to look at very carefully whether or not some of those statements are in fact maybe non-testimonial, maybe testimonial in nature. So that's what I'm required to do.
And Your Honor, we are looking at a caller who's describing and trying to get the police to respond, even when the 911 operator is asking her who was shot. In other words, she's telling her, I need you to come. I'm not sure what the apartment is. She's in building C. When you're coming around through the gates, the 911 operator is trying to get information about the shooting because she said that shot somebody, like has already shot somebody. 911 operator trying to get information about the shooting. She said, I promise you, I can't tell you all that. I ain't trying to talk to you about that. I ain't trying to give you anything for your evidence for your prosecution about no shooting. I'm telling you that the guy that shot somebody, Young Thug, is in my neighbor's house. And I'm trying to get her out the house and she won't answer her phone. So it's not about who got shot or who he is alleged to have shot. It's about he's in her house now. This man, potentially armed, is now in her house. The reason that it is important that she names him and that she says who he is and what he does is twofold. So just with the information that the court has already heard, the court already knows background, but just for future purposes, there is an accomplice statement that we intend to have presented as evidence that I will state in my place that one accomplice ran one way and Thug ran in the opposite direction. And that opposite direction is exactly where this caller is calling from. I should have followed Thug. I should have went left. I went right, or I went to the left and he went to the right. I should have followed Thug. And then here we have this caller saying, I ain't trying to talk about this shooting over here. I'm trying to tell you that this man that just shot somebody, Thug, is in her house. And I need you to get her. I need you to come and get her out because her mom and her baby are in that house.
Okay.
And Your Honor, that's the reason those circumstances, that information, the caller's words, her purpose that she reveals. When she tells the 911 operator, I can't tell you all that. I don't know. I don't know who got shot. I don't want to talk to you about that. The only thing I want to talk to you about is the reason that I'm calling, because Thug is in my neighbor's house and she's panicked. Just as if the court is going to go, if Your Honor was going to go and respond to someone, you'd want to know who it is and what it is you're walking into. You'd want to know if your neighbor came to you and said that somebody is in our neighbor's house, you'd want to know, is he armed? Who is it? That information is to help you respond to that threat that is happening right then. You would not want to walk up to a circumstance you don't even know.
Yeah, you told me that last time. I remember. So, but how is it different if if the person is directly communicating the information to me, or am I getting it through somebody else?
Your Honor, that part, it is not different for the confrontation clause analysis. That part remains the same. Its purpose remains the same. When you get into who said what, that's the hearsay within hearsay, and both of those statements fall under 24-805 to an exception. And the court analyzed it exactly correctly when the court said that's for the jury to determine, because Mr. Steele argues you don't know that was actually true. The court analyzed it on point. The court said, well, you can argue that, and the jury can say, well, she says she don't know. I don't know. The jury can decide what portions, if any, of that 911 call.
But we don't have a declarant. Our declarant's unknown. Our two declarants are unknown.
And that is why, Your Honor, the whole purpose for exceptions for hearsay are to.
This is a confrontation clause issue. How does she not realize that? I think this is intentional. I really think she plays dumb in some of these moments, but she knows better. But Glanville is clearly getting at a confrontation issue by mentioning that there's, not the opportunity for cross-examination.
Put forth things that are trustworthy. And hearsay within hearsay is not, it is absolutely admissible. And the court knows, I don't even have to say this, it is only for the purposes of the record, that these new evidence rules are rules of inclusion. So much so that the rules don't say it can be admitted if you have an exception. 24-805 specifically says hearsay included within hearsay shall not be excluded under the hearsay rule.
Well, Ms. Love, I'll tell you, Spratland, which was decided in 2023, says if I don't make a proper analysis under Crawford, vacate and remand. So,
and Your Honor,
so I got to make sure I get it right. Okay.
And Your Honor, I'm with the court. I'm absolutely with the court, and I have an equal desire, if not greater, to make certain that it is right. And I would not argue fervently for this if it were wrong.
All right. Well, let me have 5 minutes. Okay. I'm gonna take a break because your 30 seconds is never 30 seconds.
30 seconds, I'll sit.
You can stand there. That's fine.
I just want you to.
Go ahead.
I just need you to understand, and I'm not saying you don't understand, but the Carter case that was just cited, 315 Georgia 214, it's in Division 3. A doesn't apply. That's the 807 residual hearsay. B is what the state was talking about. And Your Honor,
There was no objection in this case either. So
No.
in the Carter case, no objection. So,
but look what happened.
and they had to review it under plain error too.
Yes.
So,
and
yeah.
Fox was told by Miss Mann, God forbid, Valerie Mann was killed. Fox testified. Valerie Mann, God forbid, is dead. And she told Carter. Carter testified. That is not even close. So I don't have anybody close. That's my 30 seconds.
All right.
And Your Honor, I'll give the court, if the court already has page 3 or 4 of Pitts, where the court said the caller in this instance,
Yeah, I have Pitts, yes, ma'am.
okay, was not, they were not concerned with establishing evidentiary facts or bearing testimony. That's the part against the defendant. And the court found that the same analysis was applicable in Pitts, that the 911, that portion of the 911 caller, they were not concerned with establishing evidentiary facts. They were concerned with getting Young Thug out of their neighbor's home.
Okay. All right. Give me 5 minutes. Take comfort. Y'all do this thing. We'll be back. Okay.
Oh my goodness. Chat. Oh, that was a loud Jack jingle. Oh my gosh, this is the longest argument about a 3-minute call. Wait, are we not actually? We're not actually continuing yet. He's still reading. Okay.
Okay. The court's had an opportunity to take a look at and consider Mr. Williams' motion number 40 and in respect to that, has considered the testimony as it relates to a phone conversation with a 911 operator on September the 11th of 2013. The court also has heard testimony surrounding this particular incident involving a purported shooting at the Somerdale Apartments, Somerdale Commons, as well as a laundromat that is in the vicinity where a car crashed into a laundromat. In considering whether or not the 911 call on September the 11th of 2013 would be admissible, I'll note that we have an unknown female who's relating statements from another female in regards to a situation that was ongoing at that particular point in time. The first thing that it implicates is, since the state has told me that neither the unknown females will be available for trial, then it presents the issue of the confrontation clause. So the court has had an opportunity to consider and determine whether or not the confrontation clause of the United States Constitution is violated by the admission of a 911 emergency telephone call when the caller does not testify at trial. This is similarly the issue that was decided in Pitts. So our Supreme Court in Pitts, which is 280 Georgia 288, holds that the confrontation clause is not violated where a caller's primary purpose is not to provide evidence against the accused, but to rather thwart an ongoing crime or seek rescue from immediate peril. The decision in that court cites Crawford versus Washington, which the United States Supreme Court held that the admission of out-of-court statements that are testimonial in nature violates the confrontation clause unless the declarant is unavailable and the defendant had a prior opportunity for cross-examination. When a statement at issue is non-testimonial, however, the state's normal rules regarding the admission of hearsay apply. And so some courts, it was a discussion of the court in Pitts that some courts delineate that 911 calls are totally for the purposes or testimonial because it involves a statement to a government officer. But some courts understand and hold that a 911 call is initiated by a citizen rather than an instrument of the state and is not knowingly given in response to structured police interrogation and should not be considered testimony. So the rule in Georgia is we now hold, however, consistent with the majority view, that the determination of whether a recording of a 911 call is testimonial should be made on a case-by-case basis. So the court first has to determine whether or not this particular call, and I'm referring to Williams A for the purposes of this particular motion, which is a 3-page transcript of this particular 911 call made on September the 11th of 2013. So I have to decide first whether or not the telephone call is made to avert a crime in progress or seek immediate or seeking assistance in a situation involving immediate danger, or whether or not the primary purpose is testimonial for the purposes of prosecution or to gather potential information later for prosecution. That's the first step. Also in Pitts, the court or the Supreme Court is also cautionary in terms of trial courts. However, we do caution that in certain circumstances, a caller may shift from a non-testimonial statement into a testimonial one. So it cautions us, or the decision cautions trial courts. In future cases, trial courts must decide whether a caller's primary purpose has shifted from such a manner to render portions of the call testimonial in nature and should selectively redact portions of that recording when that is the case. In this particular circumstance, the court is of the opinion, based upon the testimony that the court has heard, to include the arguments of counsel, to include the admission of the 911, hearing of the 911 call, as well as the defendant Williams number 4, and testimony in regards to the instances of the purported shooting at Somerdale Apartments, the car crashing into the laundromat some short distance away, and the purported phone call from the Somerdale Commons. The court is of the opinion that the primary purpose of the call was not for the purposes of prosecution, but more so for the purposes of relating an emergency situation. So the call itself, I'm going to admit, or is admit for those purposes and for the jury's consideration. However, going further, as Pitts directs me to do so, I will order that the portion of the call and or transcript that starts at unknown female, I have no idea, baby. I promise you, I can't tell you all that I don't know. Only thing I know is that she came running. She came to my house. It'll stop there. It will pick up. The guy is in her house. So I don't know how you all can do that. I'm going to try and get her out of the house, but she won't answer the phone right now. The particular part that I will excise will be starting at Ann told me that the guy that shot someone named Young Thug or whoever that's supposed to be shot someone. I will excise those out as those are testimonial in nature, and the court will so the entire paragraph will read, I have no idea, baby. I promise you, I can't tell you all that I don't know. Only thing I know is she came running. She came to my house. The guy is in her house. So I don't know how you all can do that. I'm trying to get her out of the house, but she won't answer her phone now. Everything else in the transcript of that call is admissible as it would relate to an emergency situation. So for those reasons, that's the court's ruling. So State, if you'll prepare the exhibits accordingly.
The court referenced the 911 call. The court mean the actual call itself as opposed to the transcript.
Whatever you decide to play needs to be redacted.
Yes, Your Honor.
Okay. So if you're going to play the 911 call, you need to redact it consistent with my order. Okay.
Yes, Your Honor.
And or the transcript.
Well, we wouldn't introduce a transcript as evidence. We would be playing the.
But if you decide that you want to use the transcript as a facilitation device later, then you would need to that would need to match, because remember, I give a tape and transcript admonition at that point in time, only if it's necessary. I don't think it'll be necessary in this case, because the 911 call case is pretty clear.
Right.
So, but I'm just telling you, if that's the case, it needs to be redacted. That would need to be redacted. So at a minimum, if you're going to play the call, redact that sentence out.
Yes, Your Honor.
Okay.
Your Honor, with respect to the court referencing Williams' motion limiting number 40, the motion limiting number 40 was not the 911 call. It was the jail call. The jail call. We did reference it talking about the 911 call. But motion limiting number 40 did not deal with the 911 call. It dealt with the statement the accomplice made to his wife on the jail call that he should have followed Thug and should have gone in the other direction.
Yeah, it blends together a couple of things. I'm not saying that what you just said is not true. I do recall that as well. So
He reminds me of, and like, kids can be super slick and think that they're going to pull one over on you, and they'll be like, they'll get home from school, they're supposed to do their homework, and they're like, can I have a cookie before I do my homework? And you'll be like, no, you can't have a cookie right now. Like, do your homework. Okay, if I do my homework, then can I have a cookie? Well, do your homework first and then ask me about the cookie. Can I go to the bathroom? They distract you, right? They go to the bathroom, they come back, they do their homework for like 2 seconds. Can I have a cookie now? And it's just like, they find these ways that even though you've given them an answer on something, they're going to find a slightly different way to ask it in case they can slip you up and just get a yes out of you. Like, that's love. Are you referring to the recording or the transcript? Redact both of them. Just redact both of them.
Mr. Steelton, can I get you prepared suitable order? And if you'll give that to Ms. Love and her colleagues so I can look at it as a final order?
Yes.
Okay. All right. Madam, anything else?
Not at this time.
Okay. All right.
I think they go to the Little Rod appeal argument.
Okay. Can we talk about Defendant Williams' motion limiting number 38? That's
So the rest of today, you guys, is evidentiary arguments. It is Love that does the arguing for the state. So we can keep this contained to Love running arguments. There's like an hour left in this. I think that'd be a good length of stream. We're watching a little faster. And then the next reunion stream we get together, we'll do all of the Laundromat incident. This September 2013 incident. We'll start watching all of that. We'll call it Laundromat Palooza. The witnesses are going to have different, it's not always going to be Love that's doing the questioning. So we'll switch the theme up a little bit. But that was a crazy incident. You know, is there a woman in the car? Is it Jeffrey Williams or is it a woman? We don't know. Is anybody actually identifying Jeffrey Williams? There's a camera that's supposed to be angling down at this. Well, do we have camera footage? No, we don't have camera footage. There's a million different layers. We're going to hear about a detective deciding, well, I thought somebody was lying, so I deleted their one statement and only have their other statement because I made the decision that they were lying in their other statement. There's a whole mess of things that happened in this laundromat incident. So I think we'll theme around an entire reunion replay about everything from about day 32 through day 40 something, all the way through Adrian Bean. That'll be a theme we start, and we can close out these evidentiary arguments. I think Glenville differs on 2 of them, but yeah, we'll get to hear Love argue against Steele for most of them and a little bit from Mr. Williams. So, did Shart argue in here? Okay, yeah. Yep, there's Shart in this a little bit. So we'll get a little bit of an assist there from Shart. And we'll keep it on 1.5 unless it gets too quick. So let me know.
To discovery, and I think that is, no, I'm sorry. That's regards to the pending appeal issue and by Mr. Ryan, Mr. Blaylock.
Your Honor, I have cited 2 cases, Gibson, GIBSON versus State, 288 Georgia, 617, it's in Division 2, as well as State versus Clemens, CLEMENTS, that is 289 Georgia, 640, it's in Division 4. Your Honor, they're both 2011 cases. I have copies for the Sound Court and the parties. Your Honor, may I approach?
Yes. Hey, Chris, let me give you that back.
So, Your Honor, on State versus Clemens, on the copy I've given the Sound Court and the parties, it's on page 10 of 11. And our Supreme Court on the right-hand side, the indented paragraph, the beginning, it reads, the Supreme Court has repeatedly held references should not be made to reviewing courts by court or counsel except to cite their decisions. And then in Gibson versus State, Your Honor, the copy I've given the Sound Court and the parties, it's on page 3 of 11, on the left-hand side, 9 lines up from the bottom, not including the footnote to the right side. It reads, our highest court wrote, based upon these reasons, as well as the rule that courts should not reference appellate courts except to cite the decisions, we held that the trial court statements to be reversible error. And then on the page 3, on the right-hand side, Your Honor, right column, in the first full paragraph, 8 lines down, the Supreme Court explains, and it's in the middle sentence, but the right-hand side, the last word, it says, and lessen the jury's sense of responsibility for the verdict. So the whole point I'm trying to make is the state, you've already ruled on it. Don't mention that I represent Mr. Blaylock. Don't mention I've represented anybody until this honorable court first weighs on it. But in the opening statement, the court may remember the state had a PowerPoint where they said that I represent Mr. Blaylock on appeal. And all I'm trying to do is for anybody, it's not just Mr. Blaylock, but Mr. Ryan is on trial with us and it affects us. He is currently on a motion for new trial. I don't know how the state intends to handle it. I've spoken with the Honorable Miss D. Williams, who is able to join this motion and cite her claim. But I don't want anyone to say that Mr. Ryan has been convicted and is on appeal and or anything about the appellate process. That's the whole point of this motion. And it will definitely come up, in my opinion, or potentially come up for Miss D. Williams, because, and I know she protects Mr. Ryan ably, but that would affect all of us because it would lessen the jury's determination according to the Supreme Court of Georgia, because they can go back and say, well, at least there's a review in court. So no matter what we do, somebody will look over it so we can get out of here. So that's my motion.
So what Steele is arguing is essentially psychologically, there's an easing of that burden. We as the jury for this trial, for this RICO case that we're sitting here for 1 million days to determine beyond a reasonable doubt whether or not the state has proven their burden on everything that they're alleging. If we're able to consider like, hey, somebody else could just pick up the dirty work and on appeal, just say, hey, that wasn't good, throw it out. So we have... It eases it subtly, subconsciously could conflict with the burden of proof here. So good argument from Steele. Although I guess the counter argument could be, and there's case law that supports this, but as a counter argument, I'd be like, oh, they're appealing. What's the appeal argument? What did they get wrong? So, but the case law does support what Brian's arguing here.
I just don't want anybody to mention the appellate courts, my representation, or that Mr. Ryan specifically. And I don't believe anyone else in our case that I know, but I may be wrong, but I don't know anyone else who has a pending appeal, but I mean, who's indicted, but I could be wrong, but that's my issue.
Okay, all right, but that was made during opening statement. I don't think it's been made any other.
No, I wouldn't think that that would come up again after the court's denial of my motion for mistrial.
Okay.
But you made it clear.
All right, okay. All right. State, anything?
Your Honor, not at this time. If the matter comes up again, we'll address it with the court before mentioning anything like that.
Okay, all right, because it does, both, in fact, State versus Clemens mentions that every reference to an appellate courts during a trial is reversible error. So, and then of course I have, but yeah, as I mentioned earlier,
As we stated, there may be,
if it comes up, I need to hear about it during your case in chief. I definitely want to, before it comes out or is elicited
Or an opening statements, maybe.
from any witness, I would need to, I want to review that because, the appellate courts are pretty clear. I mean, I think in Clemens, that's what was mentioned, and also in Gibson, in terms of just, I think the court instructed on something and the appellate court said, no, that's not, can't do that.
and that would be the court commenting on it.
Yes, commenting on it. So,
As I understand Defendant Williams' motion in limine number 38, he's asking the court to order a thing. But again, it has not, and we've stated to the court previously that before we bring that up, I don't think he's asking that we not mention Mr. Ryan's conviction for murder. But I thought that's what I heard him orally say, but I don't think that that's in the corners of the document.
well, that would depend as well on.
Because we do intend to mention that. We will be talking about that. That's one of the overt acts.
Oh.
So we will definitely be bringing evidence in that Defendant Ryan was convicted of murder and Defendant Blaylock was convicted of murder. And prior to, or if we decide to say anything regarding Mr. Steele's representation of YSL members, we would bring that to the court's attention, as we stated way back when this was first broached.
All right. Misty Williams, anything, madam?
We just go ahead on Mr. Steele's motion. I didn't want the state to bring up the conviction for murder.
I'm sorry.
We didn't want the state to bring up the conviction for murder.
Well, I think we'll probably need to take that up because that's alleged in one of the counts as an overt act.
They have to prove that too, so.
Sure.
The conviction is part of the proof. And so that would be excluding a verdict, and that the case law specifically does not preclude that type of evidence from coming out. I don't even know where that argument is, what case law or anything that's grounded in.
Well, before you tender or make an effort to do that, let's put a pause on that and let me just consider I need to see some case law on that just to make sure. I mean, I'm fairly certain I know where you're headed, but,
And we would not, also just so that the court is aware, what I heard referenced previously was the prohibition from the courts of attempting to prove the existence of a gang by introducing simply a certified conviction of someone not on trial, not testifying. And that is not at all what we would be doing. We would be putting up evidence of the murder itself, evidence of what Defendant Ryan said after the murder regarding YSL, evidence of what Defendant Blaylock did regarding YSL and what he said, slime over sluts, and Defendant Ryan saying, I bet YSL make the news. We would be putting up the murder of the victim, Jamari Holmes, by defendants Ryan and Blaylock. And again, the only portion we would be putting up evidence of that and how it occurred and how close in time to the murder Mr. Ryan made the declaration that I bet YSL makes the news. We would pause, I suppose, if that's what the court is saying, prior to tendering the certified conviction of defendants Ryan and Blaylock. And then if we had to bring up Mr. Steele's representation of defendant Blaylock on appeal or anyone else, we would bring that up before introducing that.
Okay.
And if that's in.
yes, ma'am.
Okay.
All right. Okay. Who are you? You just kind of got up and just kind of, lurked your way toward the front or something like that? Okay. All right. So how are you asserting yourself into it?
I think I need to, on behalf of Mr. Stillwell, we are, and I know that we said we're going to perhaps put a pin in it, but I want to make this very clear. On behalf of Mr. Stillwell, and I think probably on behalf of other defendants as well, we are objecting under the Jefferson case to informing the jury of another jury's determination of guilt versus innocence of Mr. Blaylock or Mr. Ryan, this jury needs to make a finding of fact on their own and can't rely on the finding of fact of another jury. And it affects us because that is alleged as an overact as it relates to count 1 in the indictment. So we are not acquiescing to any belief that this jury can rely on the findings of another jury to.
I understand that. That's why they're going to put all the all the proof in front of them. And,
Right.
And,
So,
but whether or not the conviction itself.
Well, if we're putting I'm sorry, Your Honor, but if we're putting the proof in front of the jury, then they make that determination whether it's been proven. I don't know why we would present in front of them. Why would we present the proof in front of them?
Because it's part of the overt act.
But a previous jury's
and what's your
finding is not part of the overt act.
No,
we can't rely on this jury cannot rely on the findings of another jury.
They need to make that decision for themselves.
Absolutely.
But the fact that there was a criminal prosecution in this particular case, it's the convictions in the proper form, it's more than likely going to come in.
Well, I will come on.
I mean, I remember you have cited Jefferson to me in the past, so I understand that. The concern I'm dealing with right now is whether or not Mr. Steele's involvement in any appeal or his involvement in any counsel is relevant at this point. I don't find it to be at this point.
Right.
So, but I will take a pause before they introduce anything about a conviction that was had, but just to make sure.
Yes, sir.
Okay?
Okay, thank you.
All right. Okay. All right. What about Mr. Williams, 39? Mr. Steele? And I believe that involves victim impact evidence?
Yes, sir. That's right.
All right. And the life of Mr. Thomas.
Your Honor, may I approach for a moment?
You may.
Your Honor, I have a good faith belief that there will be people, and I'll just specify Mr. Donovan Thomas family members have been announced here on the witness list, and the ensemble court excluded them under the victim rights bill from the rule of sequestration or parts of that family. And if they testify at our trial, I want to make a motion limiting now, and it's under Waller, W-A-L-L-E-R versus State. It's 368 Georgia Appeal, 378-890 Southeast 2D 142, 2023 case. Your Honor, the copy I've given the ensemble court and the parties, it's in Division 2. It's on page 4 of 7. On the left-hand side, the last full paragraph, the court wrote, under Georgia law, evidence about a crime victim's personal characteristics and the emotional impact of the crime on the family, the victim's family, and the victim's community generally is not admissible in the guilt innocence phase of a criminal trial. And Your Honor, upon basis of work leading up to the case, Mr. Donovan Thomas did a lot of great things for the community. He was well respected, well loved. There's another side to that, which I'm not going to mention. It may come out at the trial, and you've heard it actually from Detective Belknap. He already testified that he was the leader of a criminal street gang. But my point is the fact that it left a gaping hole in the community or the loved ones, I'm making a motion that is irrelevant in our case. And I'm not talking about the relevancy of, 401 and 402, even with a 403 analysis. I'm talking about it goes to sympathy. And the courts have said that it is not admissible except in a rare circumstance in the guilt innocence phase of a non-death penalty case. So that is my motion. So I'm making it preemptively. I've heard at the beginning of the trial, and I made this motion afterwards, Your Honor, but I heard the very first incident. It did not involve anyone here, but involved Mr. Trontavious Stephen. And you heard from a young lady, and I can't remember her name, but she was an accountant at an adult entertainment center. She was followed home or driven home in Coweta County of Union, Georgia. She was, her car was stolen from her, and the prosecutor went through lots of questions. I did not object, but went through lots of questions about I objected to the whole thing coming in because Trontavious Stephen's not on trial with us, but the court allowed it in and went through a lot. That how did this affect you? What do you do? How does this impact you? And I'm not going to. I don't want to hear that again. So I believe it's a violation of law.
All right, counsel, for state, Ms. Love.
Your Honor, I'm not intending to elicit, and I don't believe that we will be improperly attempting to or even eliciting any good character information of that nature. We have not done so thus far. We will not do so in the future with any of our witnesses. So the idea that has been done or that we intend to do it, I'm not certain where that's coming from. So I don't believe until that time that Mr. Defendant Williams believes something like that has happened, and I don't believe that will occur. I don't believe that this is anything right or any ruling, but we know the rules of evidence and we know what we are supposed to and not supposed to introduce. So we won't be eliciting any inadmissible and impermissible
Victim impact evidence.
Right.
All right. Well, I'll grant it to the extent that it's not relevant at this point in time, but if appropriate, later, if in fact a jury returns a verdict, then I can deal with it at that point in time. Okay.
And there was one other thing co-counsel reminded me to bring to the court's attention. What the victim was doing on the date that he was murdered, I don't know if it would be considered good or bad character, but we do intend to put that evidence in because those are the circumstances surrounding his murder. So, for instance, if he was standing out giving candy away to kids or playing Santa Claus, somebody might consider that good character evidence.
What is he selling drugs?
Or if he was selling drugs, they might consider that. But the point is that what was happening that day, and he was not, but if that were happening, those are the circumstances surrounding his death. And we would certainly be looking to, get in, or if he was paying for children's haircuts, things like that. We would be putting that, we would get that.
Well, that would depend upon what you present in that respect.
Right.
Okay. All right. Okay, what about let's see. I have motion to limit number 41, Mr. Steele. I believe that's a incident involving May the 12th of 2013.
Right. I'm aware.
Involving Miss A.B.
Yes.
And a purported armed robbery.
So may I have just 1 second, Your Honor?
Yes, sir.
If that's okay.
Whisper, whisper.
I apologize, Your Honor.
That's okay.
The state may have conceded, but I wanted to check with them before I say something. So they're conversing.
Right. I said it in the chat, but I'm going to recite my snark out loud. So I think that the state wields, when I say the state, I don't mean every prosecutor. I mean in this this district here seems to wield victims, family members, and even victims, living victims themselves as weapons. They proudly proclaim to be advocates for victims, but then they seem to disregard the victims and the victims' family members when it works for them, when it's convenient for them. And in relation to this argument about, oh, we're not going to use Donovan Thomas's parents to put them on the stand and introduce character evidence, we're not going to try to introduce this PowerPoint slide. Remember the Operation Planters PowerPoint slide with the funeral pictures for Donovan Thomas's funeral. And Love has the hot mic moment when Whitaker's like, why would this be relevant? And she hot mics, oh, he was loved. Well, we get through this trial. We have the remaining co-defendants awaiting trial 2. The last person awaiting trial that's charged with the murder, the death of Donovan Thomas, is Demise McMullen. And what ends up happening with Demise McMullen? Well, the state offers him a plea deal where the murder charge is reduced to aggravated assault. And yep, so Aaron, moving over to Shamel Drinks, did the family members of the victims get a phone call when Garlington took a plea? And what's interesting is in this indictment, Garlington isn't charged with the death of Donovan Thomas, but he was initially part of the core group that had eyes on them until Sprinkle reworked while doing his case intake, who was ultimately going to be indicted. So not exactly the same because there was no charge there, but if the Thomas family felt like maybe Garlington still had something to do with it, whether or not he was charged with Donovan Thomas's murder in this indictment, that's kind of a little bit of a slap in the face as well. And we heard during the trial that Shamel Drink's family, at least certain family members, I believe the aunt, was upset with the way the state was handling the case and how the investigation into Shamel Drink's death was handled. And I think when we heard all this, well, we have a still, but we didn't grab other stills and we didn't pay attention to the other car. I think that was infuriating for a lot of people. Right, that have no direct connection to any individuals named in and around this case. So,
Excuse me. Stand by yours.
get it together, love. How long do they do this? All right, there we go.
Okay, so this is it's May 12, 2013. If it matters to the court, it's Mother's Day. It's a Sunday, and it's approximately 1 o'clock in the afternoon.
So this is, remember I said earlier, just keep in mind we have these apparent incidents from back in 2013 where Young Thug is somehow named by somebody eventually, but in kind of vague ways, unverified ways, things that he wasn't charged or sought after for in 2013. Just like that September 11th, 2013 911 call that was at issue earlier. This issue is a different argument, though. It's the state didn't notify the defense that, hey, we plan to introduce this.
And the allegation, I'm not agreeing with these facts, I'm just telling you what the allegations are in the police report, is that Mr. Williams, along with a person, it's not identified that way, but I'm going to say Mr. Murphy, Walter Murphy, you've heard him known as DK, you've heard that, and he's a co-indictee. And it's alleged to be, I don't believe it is, but it's alleged to be a brother of Mr. Williams, but that's how the police report reads, and that's what the officer told me that he was told by AB. AB says that there's a knock on her door. She's with her young child, infant child, opens the door, recognizes Mr. Williams. Mr. Williams, she says, is friends with her significant other. His name has come up in this trial. You may remember him. His name is currently escaping my mind, but he's known as Ola Playa, Playa. Yes, that's right. Micah Anderson is the name. He's come up earlier, Your Honor, on some of the recordings, music recordings that the state introduced that we cross-examined. Supposedly, AB turns her back. She's holding her child. She's, I believe, cooking, goes into her apartment. She says there's a gun at her face or back of her head. She turns around. $400 in U.S. currency, she alleges, is taken. Her wallet is taken. Jewelry is taken. Her bag, which contains her baby products, is taken, and her gun. She says that Mr. Murphy, who's known as DK, fires a round of gunshot into her wall of her apartment, and the perpetrators leave. She does not do anything that day. Meaning, when I say that, there's no call to the police. She states that upon the next day, her house is it's an apartment. It's a connected apartment. It has bullet holes in it. The house now, and there's bullet holes in the exterior and through the window of her apartment. She states that the next day, so it's going to be that Monday, she walks to the police department and tells the officer what I just told you. That's basically the police report. The officers drive her back to the apartment. She states that a neighbor told her that during the night, the people came back and shot up her apartment. I believe the state wrote, that's what I was conferring. They wrote a written response that I read. They're conceding that cannot come into evidence. Who shot up the apartment, because the neighbor is unknown. It was said to the police officer, it's confrontation clause and hearsay. I know you know all that. I believe they're conceding that. If they change their opinion, then they said they'll speak for themselves. But so I think that's part of my motion in paragraph 4. And there's supposedly also a child who talked directly to the officer. The officer told me that he does not remember that child's name. It's in the report. Has no idea who the child is. And the child supposedly saw a person shoot around in the apartment. So I think the state is conceding that as well. But I'm asking you to exclude, this is not charged conduct. This is outside of the indictment. I received no notice of it. When I say that, I mean, I received no 404B notice. The state's response says that they don't have to give notice because it's intrinsic. That's the state's position, that this is an intrinsic act. And I agree that if it's an intrinsic act, it does not have to get noticed because it can't be separated from the controversy that's on trial. It is needed to explain the conduct, or it's so intrinsically intertwined with our trial that it cannot be separated. I don't believe that this is intrinsic act evidence. The reason for that is threefold, Your Honor. The first one is the allegation is that Mr. Williams and the two other people are supposed to, and this is not my rendition, I'm just saying what I believe the state, I'm giving it to the state.
I think we covered this earlier. Yes. I want to say in November. And I think that, are we going to have her testify, AB?
Yeah, the state said that she's they gave us a notice that she's coming either next or two.
Okay, so if you interview her, would that change part of this? I mean, it certainly the second portion of place being shot up or whatever else, but I think I've kind of...
You satisfied the notice of, I can interview her. Your Honorable Court put down its gavel and the state came through, provided me contact information. That is not the issue. I'm now saying I don't want this other act evidence to come in. And I don't believe it's intrinsically entwined and it needs to complete the story because the state has 191 acts total. Those all do not involve Mr. Williams, but they have a total of 191 acts. At some point, they don't need more acts. This is under 403 analysis, Your Honor, as well, because the prosecutorial need for this evidence is so small. If they can't prove this case, and I'm referring specifically to the RICO conspiracy count, which is count 1, and that's what they're claiming is part of the intrinsic act.
That's beautiful to hear now that we know what the jury decided about RICO.
That this gang, quote unquote, these YSL members go and they commit robberies, armed robberies.
They're introducing, because I'm looking at the transcript from that hearing, Ms. Love tells me they're going to introduce the 404B problem.
Well, they changed. So I don't want to, it's not 404B, I don't believe. I think they're saying, and they can tell me if I'm wrong, but I don't believe, I got no notice of 404B. Is it going for state of mind? Is it going for plan? Is it going for knowledge? They blew the statute, but I believe that, to be fair, I believe that the state's response, which came recently, says it's intrinsic. So they don't need to put me on 404B notice. But intrinsic act evidence still has to be intrinsic. And there is no reason that I could see why we need the fact that an independent supposed armed robbery occurred on May 12th. This is not part of anything significant in the indictment. It is not an indicted conduct. Mr. Williams never arrested. Mr. Murphy was never arrested. The supposed brother, who I'm telling the court, it's not the brother, but regardless, that's how it's written in the report, was never arrested. The reason for that is this, Your Honor. I think this is important for the court. The police officer get this information, and they start calling AB, and AB will not respond to the police at all. And AB is deemed by police, it's in the report, that she has given false information to law enforcement.
Okay, you're gonna cross-examine about that, right?
They're all coming.
Okay, yeah, so.
Except for what I told you about the child and the neighbor.
Okay.
AB, the police officer, the crime scene people are coming to court. I have.
That's part of why I defer ruling on. So, okay, so it's still of your opinion that the subsequent shooting up of the apartment and this child's statement by the child, or are you asking to exclude those? Is that correct?
Not the subsequent shooting, because that may be part of, why she went to the police. So that may be intrinsically intertwined, but the child statement, the neighbor's statement saying, I saw it happen, I can't cross them. The state's conceding it. It was said directly to the police officer. That was not an ongoing emergency. It was the day before. So, yes, those are out. But I don't want the armed robbery to come in. That's my issue is I don't want AB to be able to testify that she was supposedly the victim on May 12th of 2013 because it's other act evidence. And I am claiming, I know what the state, I hope I articulate, the state has claimed not 404B, but it's intrinsic. I'm saying, how is this intrinsic?
Is it part of count one?
No.
Is it an element of proof?
No.
It is.
Which count?
Your Honor, it goes to count one specifically because this wasn't first of all, it was committed by the defendant Williams and
Walter Murphy?
And Walter Murphy, 4 months before the evidence that the court is now hearing about with respect to Mr. Dotson, which was also, as we allege, committed by Mr. Williams and Mr. Murphy. And it was during the time that we are alleging the gang itself started. It was the type of crimes that the gang commits. It goes to prove the existence of the enterprise and the gang, the nature of the crimes that they commit, and the members and participants in the enterprise itself. So it is intrinsic for those reasons. Mr. Steele notes in his motion that there was no notice received, but not only was there a written notice of our intent to use it and introduce it, we argued and he corrected some of the.
Yeah, because we had a hearing on the issue on November the 21st of 2023. So, yeah, Mr. Steele, I think I'm in a position at this point in time to, now I've heard a little bit more testimony. If assuming the state can lay a predicate, it's probably going to come in.
Well, okay. How many more times does the state of Georgia need to show a relationship? They say 4 months before another act. Mr. Williams not charged in overt act 5, 6, or 7, which is what they just referred to in September 11th, 2003. He's not even charged with that. That's other act conduct. How much of this do we need to absorb on our vessel before it starts sinking? And to me, the state has to say that it shows everything they said goes to propensity. It shows that they commit these type of crimes. You have that. They have multiple murders in this case. Multiple murders. There's going to be 2 murders that are going to be litigated. Mr. Williams is not charged with either one, but we have to deal with that. That's other act evidence, and he'll be named. He'll be named in both of them. We're going to be active participants, even though he's not charged. Then you have the incident that we're doing with the 2004 Nissan Altima red vehicle slamming into the side of the building. Mr. Williams not charged with that, but the state got that in as intrinsically intertwined because they indicted it, and now Mr. Bean cooperated with law enforcement and is on jail calls saying that Mr. Williams was involved. Then they have Mr. Williams' lyrics with their over objection, where they're claiming that he's bragging about. How much more do you need? We have chats who he's speaking with. He speaks with Mr. Murphy, who will be a witness. The state states he pled guilty already, and he's supposedly a witness in the future. He's going to say how he and Mr. Williams were both raised together. They don't need to show the association, and they don't need to show another crime. At some point, it's just too much on the 403. And I still don't believe, Your Honor. I heard what you said. Does it prove an element of the crime? The elements of the crime are either going to be proven or disbelieved by the state. They don't need this. That's my argument.
Okay.
I heard what you said. I'm not trying to waste.
No, I understand. All right. Ms. Love, anything else, madam?
Your Honor, just that, we have to prove this case. Their argument is that the defendant Williams doesn't do any of this. And we have to show the jury the evidence that he does and that he did. So I understand it's not comfortable to have evidence presented that you do the crimes that the state is accused you of, but that doesn't mean that the state should be precluded from producing for the jury who is to make that determination, evidence that in fact Mr. Williams did and does the crimes that the state has accused him of. So we are asking that the court deny the motion.
I'll deny Williams 41. Now, to the extent, are you still going to try and, or is the Mr. Steele's proffer that you're not going to get into what the child said or what was said about the shooting up of the apartment? He says the shooting up of the apartment may be relevant for other purposes, but the conversations
Right,
that precipitate those, you're not going to get into those.
Right, so we would get into that it was shot up, and that's what precipitated her going to the police.
All right, okay. But you're not going to say what was said, is that right? Or what the child said?
Correct, what the child said, that's our intent, not to introduce what the child said, correct.
Okay.
Just the fact that she didn't initially go to the police after the robbery occurred, but when people came and shot up her house.
She went.
To the
Okay, all right. All right, to that extent, I will deny Mr. Williams 41, but with that caveat in the sense of what will be admissible in regards to the incident of May 12th of 2013.
And Your Honor, in relation to.
Oh my God.
Listening to the court.
Is this going to be the kid asking another way if they can have the cookie?
Ruling there, in relation to what the court said about defendant Williams' motion, we were talking about motion number 40, but we were talking about the 911 call. So the court's ruling was that it denied the motion to exclude the 911 call, but with the caveat that a portion of it was to be redacted.
No, I agree. I'm gonna allow the 911 call
Okay.
with that caveat. I am going to allow the 911 call because I find it to be an emergency. But I've redacted that particular portion that references that statement, that's testimonial.
So Your Honor, would the court prefer that the state, since the defendant moved to exclude that call, would the court prefer that the state present to the court proposed order?
You can submit one and show it to Mr. Steele, and I'll look at it. Okay.
Yes, Your Honor.
But that call, since it's going to come in, it needs to be redacted, and Mr. Steele needs to hear it, and it needs to comport with what I said. Okay.
Yes, Your Honor.
Okay. All right, folks, it's noon. Mr. Steele, we're going to table your motion to exclude or redact the conviction of Mr. Winfrey and then motion for notes and recordings from Mr. Wise. I'll take that up at another time. I think we've used our time for the morning as best we can. So,
Did they really? Did they use their time the best they can?
all right, so folks,
Yeah, I think they wind it down here. Like actually wind it down.
tomorrow, Wednesday, the 23rd, 1000 hours will start at 10:30. And our jurors
10:30.
will be here for that time. Anything else I need to be made aware of or ministerial in nature?
Just for the purpose of making certain that we have witnesses and scheduling properly, we will go until 5 or 5:30. Around that
Somewhere
time.
between 4:30 and 5 o'clock. Yes.
Okay,
Yes, ma'am.
thank you.
Uh-huh.
You see her trying to get in the good graces of the court. Oh, can we for scheduling and to be efficient tomorrow? Can we go to 5 or 5:30? Like that's very goody two shoes.
We'll probably end closer to 4 is what I'm thinking.
Okay.
Okay. All right. All right. Folks, then we'll be in recess until tomorrow. Okay. All right. Thank you for your patience. We're in recess.
So there's that. We're gonna wrap this one up with a little treat from Erin, formerly known as Adventurin or Adventurin. I'm not sure on the proper pronunciation there, if we're supposed to roll it together. Now, during the trial, a lot of people were saying, hey, there was another case that Glanville was on, and maybe he made a rash decision. It was the wrong decision, and it may have let a potential murderer go away without ever having a trial, without ever letting a jury decide if they were guilty or not. So maybe that's why he's so relaxed on his time management this time around, because he's so nervous that he might make the same mistake. He's overcorrecting. So Erin had went and found, I'm pretty sure this is the case people used to refer to. Erin found this while just looking through something that attorney Siri Shada Jimenez had referenced when relying on case law about mistrials. And we're going to read a quick story, a quick throwback here, where Glanville set a precedent. So, judge's error could set man free without trial for murder. We're back on February 9th, 2016. A mistake by a Superior Court judge means a Georgia man charged with murder may go free without a jury ever weighing on his guilt or innocence. The case started on June 17th, 2013. Hey, we were back in time in 2013 with almost all of the arguments today. When police say Gary Otis ran up the stairs of a high-rise apartment building for seniors and attacked 71-year-old Emmanuel Surrey. He kicked down a metal door and stabbed 75-year-old Mary Oliver to death. Police had to use a stun gun to subdue him, according to court records. Otis, who was 64 at the time, was a resident in the building, but didn't know Oliver or Surrey, Fulton County District Attorney Paul Howard said. Oliver was asleep in her bed, and Surrey had just returned from taking his uncle to the hospital. Otis was arrested and jailed. When his murder trial began on April 7th, 2014, public defender Amanda Grantham told the jury in her opening statement that Otis, quote, just snapped. The only possible verdict is not guilty by reason of insanity, Amanda Grantham told the jury. Prosecutors were caught off guard. They objected, saying they hadn't been notified of an insanity defense and needed more time to prepare. Grantham, this is the defense, said she wasn't required to give them a heads up because she didn't plan to call any expert witnesses. She's just going to call lay witnesses. The judge overseeing the trial, Fulton County Superior Court Judge Ural Glanville, said he believed the law required prior notice. He didn't want to keep jurors long enough for the trial to be rescheduled, so he declared a mistrial. So, look at this reasoning. He didn't want to keep the jurors long enough for the trial to be rescheduled, so he declared a mistrial. He said he'd put the case back on his trial calendar in a couple of weeks. Quote, we have a quote here. He's a very well-regarded judge, said Georgia State Law Professor Jessica Gabelsino. He did what he thought was right at the time, given the circumstances, at that point in time. Grantham didn't want a mistrial, though, and she challenged the judge's decision. She argued that a jury had been seated and that the trial had begun, and retrying Otis would amount to double jeopardy, which is when a person is improperly tried twice for the same crime. Glanville rejected that argument. Grantham appealed to the state Supreme Court, which on Monday said the judge had erred and reversed the ruling. The justices said in a 1995 ruling makes it clear that the defense doesn't need to provide notice of an insanity defense if no expert witnesses are to be called. So the decision there, the Judge Glanville accepting the objection from the prosecutors, he accepted their argument, agreed with their argument. Supreme Court of Georgia says, no, the case law says they don't need to provide this advance notice if you're not going to rely on expert witnesses to present this. That opinion came during the sentencing phase of a death penalty case, and Glanville interpreted it as only applying in that context. The Supreme Court disagreed. In a concurring opinion, Justice David Namias said the Superior Court rules need to be revised. It is apparent that the trial court in this case was striving to produce a fair trial, but the court erred in not abiding by our holding in the earlier case. Glanville declined to comment through the court's public information office. I didn't even know that they really used that, so I don't think that this is just... I could be wrong, but it might not be like, hey, they use this thing all the time, and they're always chatty patties, and Glanville was just a bit glum on this matter. Fulton County District Attorney Paul Howard said the High Court's ruling is beyond belief and shocking to the consciousness of justice and fair play. He said his office would request reconsideration. So, you know, sad for the family members. But to me, when I looked at this, it seems like that's kind of an issue of not being quick to dismiss the jury, but rather being quick to agree with the prosecution's analysis of a legal issue. So let's see. Did this repeat itself or did it scroll me back up? Yeah, that scrolled me up a little bit. So I think we were actually here. So we're back down to the family member saying it was a mistake on the judge's behalf. By all means, sanction the judge and give it to another judge. But he should not walk free. What kind of message does that send if we just let murderers walk free? If the Supreme Court declines to reconsider its unanimous ruling, Otis will likely be released in several weeks after being in jail for 3 years. The social workers in the public defender's office are working to set him up with the help he needs. Brian Grantham, the husband of Otis's trial attorney, who joined the case on appeal to help his wife, said he doesn't believe Otis will be a danger to anyone because he doesn't have a violent history. I think he's a little shocked because he's been sitting in jail for 3 years and honestly probably thought he was never getting out of custody. Now he's got a second chance at life. So interesting side story there. And, people had mentioned that maybe a lot of Glanville's behavior now was overcorrection, right? Instead of being quick to rush to a decision, let's defer at this point in time. We're not going to deal with that at this point in time. I'll wait until we have the relevant witness and we'll revisit this matter at that point in time. So I don't know. If we went back in transcripts, I wonder if he's always used at this point in time or if it's something that emerged and became part of his regular usage after this. That'd be really interesting to see. So, and hey, Bama girl, good to see you. But yeah, thanks for that side story adventure there. Adventure and taking us on an adventure. And speaking of sentencing, right? We didn't really have a guilt and sentencing phase with the Kohberger trial because he took a plea. But we have sentencing for Kohberger this week and a lot of reactions to it. I've steered a little bit away from it because some of the commentary I've seen, and I have a real particular granular gripe, a pet peeve. Some commentary I'm seeing is just a blanket statement about plea deals. He took a plea, he's guilty, and I'm sure you guys don't need me to spell out why I don't like that line of thinking, right? And we watched a whole trial involving several pleas here with the YSL RICO indictment, where are they really, is everything contained in this plea true? Is it for real? Or are we just signing it to get out of Rice Street? Right? So I've been a little bit like, I haven't wanted to go to war and argue with people over their opinions about the Kohberger case specifically. But when I see that specific sentiment about plea deals always equal guilt, I'm like, no. So, but I think one of the best people to talk about sentencing, and it's going to get me caught up on some of the details that I missed, is Andrea Burkhart. She's an attorney that does a lot of appellate work, and she's very familiar with having to understand, victims and their family members need to be able to say their piece, but if it's done in a prejudicial manner, it could become an error. It could become reversible error. And that would obviously be more important when we're dealing with a capital case where there's a guilt and sentencing phase, right? But we'll see. We'll see what she has to say. I agree, factual lie. Love Andrea. She's so incisive and she's so thoughtful and has a great way of explaining, the big picture and the nitty gritty. So we'll be over there. Yeah, and yeah, Aaron. So to close out the Otis Geary story here, or Geary Otis. So I'm getting confused because Don Geary, another Georgia name, last name Geary, but here Geary is first name, Otis is the last name. But yeah, Supreme Court does not reconsider and Geary cannot be tried again. So there we go. Double check that this is saved to redirect over to Andrea. And even if you're not interested in the Kohberger coverage, definitely give Andrea a subscription when she does cover a case. Like, her analysis is awesome. You'll learn a ton over there. And Angelica, that's exactly where I sit with it. After the YSL trial, I no longer think pleas always equal guilt. And, I reserve the right to think somebody pled guilty and I do think that they're actually guilty, right? I'm not saying that plea deals are always something that you can just disregard as if they're completely meaningless. But just that sentiment that they always, every letter in a plea is truthful. It's a true acknowledgement. It's a real acknowledgement. Everything that led to this moment is now acknowledged as actually having happened. I can't get behind that. So, and there we go, you guys. This is going to get us right over to Andrea. She's live now. Say hello when you get there. And tomorrow we'll be back for Sandra Dorley, the Monroe County, New York District Attorney that is asking, hey, I know you want to censure me, but just let me finish up my work here and let me move when I want to move to my new house in South Carolina that I bought. Like, let me just ride off into the sunset without any real repercussion. So we're going to read her deposition together tomorrow. If you want to tune in, come hang out, and probably be back Monday with some YSL Reunion over the Laundromat incident. So there we go. Everyone have a good one. Bye, guys.